DStv 47, the home of untold stories.
Defend this constitution. That's every person. And that any attempt to establish a government otherwise than in compliance with this constitution is unlawful. Article 10, the national values and principles of governance in this article bind all state organs, state officers, public officers, and all persons whenever any of them applies or interprets this constitution, enacts, applies, or interprets any law, or makes or implements public policy decisions. Public policy decisions. And then it goes to list the national values, and the ones that I'm interested in are good governance, integrity, transparency, and accountability, and perhaps national unity, rule of law, democracy, and participation of the people. Article 47 on the rights to fair administrative action, that states that every person has the right to administrative action that is expeditious, efficient, lawful, reasonable, and procedurally fair. If a right, and that's where I'm interested, if a right or fundamental freedom of a person has been or is likely to be adversely affected by administrative action, the person has the right to be given written reasons for the action. And Parliament shall enact legislation to give effect to these rights in clause 1. And Parliament did enact the Fair Administrative Action Act 2015, which defined an administrative action. I want us to go to Article 129, which provides for executive authority and the principles. And I'm interested in one, that executive authority derives from the people of Kenya and shall be exercised only in accordance with this constitution. The Article 131, and I'm interested in clause 2, the president shall promote and enhance national unity and safeguard the sovereignty of the republic. Those are the ones that I'm interested in. And then Article 259, that this constitution shall be interpreted in a manner that, I'm interested in A, promotes its purposes, values, and principles, and 2, if there is a conflict between different languages version of this constitution, the English language version prevails. And then I think that is about it. And then the 6th schedule of section 7 of the 6th schedule, which talks of all law in force immediately before the effective date continues in force and shall be construed with the alterations, adaptations, qualifications, and exceptions necessary to bring it into conformity with this constitution. My lords, the issues that have been raised in this appeal touch, in our opinion as 254 on two main issues. That is the sovereignty, the concept of sovereignty, and the concept of supremacy of the Constitution as a law. And I'll talk about sovereignty, although I'll refer you to page 2463 of volume 6 of the Record of Appeal, the Attorney General's Record of Appeal, volume 6, page 2463, where our submissions at the lower court, at the High Court, on sovereignty were, so that I don't have to talk much about it. And that the Constitution requires that, or has provided, that the people are the owners of sovereignty, and that they can exercise it directly or indirectly, so that there are two exercises of sovereignty. One is direct and another is a delegated exercise. Not a delegated power, but a delegated exercise of sovereign authority. And the Constitution has also created the aspect of delegated power. Sovereign power, once delegated, is no longer sovereign. It is delegated power, and it is inherently limited by the Constitution, in the sense that by the nature of delegated power and the principles of delegation of power, even contained in Article 94, where we get glimpses of how delegated authority works, delegated power is inherently limited and has to be limited. So we have those two versions. There are different manifestations of sovereign power and different different capacities of sovereign power. The fact that the people exercise sovereign power directly, what are the ways in which they exercise sovereign power directly under our constitution? They may exercise it through voting. That is, when you go to vote, no one can ask you to vote a certain way, or no one can question your vote because it's sovereign power, but it's exercised at an individual level. But that is a separate capacity. For instance, when we are electing the president, for instance, the sovereign power necessary for electing the presidency is not just your individual capacity of sovereignty, but a different capacity. And I think that's a distinction we need to make. I view sovereignty as, for those who are Christians, as something sort of like the Trinity, where you have God the Father, the Son, and the Holy Spirit. They are all sovereign, but then they have different capacities of sovereignty. And that's how we need to view sovereignty. And it may answer the question of who are the people. That the people is you and me, but the people is also the people collectively. And I'll explain as we go on. Supremacy of the Constitution as a law, and what I want to demonstrate on this one is that there is an inherent non-absoluteness of any law where there is a supreme law. Such that when you have a supreme law, any other law cannot be deemed to be absolutely binding. It will only be binding to the extent that it is consistent with the supreme law. And that's the same for sovereignty, that as long as you have a sovereign, anything else below that will never have an absolute bond. I'll take 10 minutes to talk about the cross-appeal issues, and they will relate to this. And the cross-appeal issues that we had were that, number one, we wanted the Superior Court to declare that certain proposed amendments were unlawful because they were not consistent with provisions of the Constitution. And here I want to make a distinction between a proposal to amend the Constitution, as was in this case, and an amendment under the amendment process itself. That the task forces had initially proposed to amend the Constitution. These were proposals. And proposals, because they are coming from the executive, which can only exercise authority that is delegated and as authorized by the Constitution, are subject to all the other limitations of all executive authority. That includes Article 47, they must give reasons, the reasons must be rational, they must be justified, and the proposal must be necessary. And we try to persuade the court using Article 10 of the Constitution, the rule of law, accountability and transparency, and Article 47. We presented a document labeled CE5, and we'll find the documents from page 2422 to 2447, together with an affidavit where we were able to break down all the individual amendments and show the ones that were irrational or that seemed irrational to us, the ones that were unjustified, and the ones that were not necessitated. Rationality being that if you're solving a problem, the solution has to be consistent with the problem. It has to relate rationally to the problem you're trying to solve. A necessitated amendment is one where you have actually either there was no other way to solve this amendment, to solve the problem, and that is why you opted for a constitutional amendment, to propose a constitutional amendment. And a justified amendment is one which there are reasons stated for that amendment, that either the people asked for it or that there was a problem you are trying to solve. But you cannot come from nowhere and arbitrarily give us a proposal and claim that it cannot be questioned. Having demonstrated that, we wished that the Superior Court state that some of the provisions in the proposal, some of the proposals by the task force were irrational and not necessitated and unjustified, and therefore should be scraped off, or that the Attorney General be directed to review and have only those that meet the edicts to go through. And a specific example that I would want to give is an amendment on IEBC. That is found in the page 2457 of volume 6. And it talks about the restructuring of IEBC in the proposed amendments. And it doesn't give reasons anywhere why they were restructuring IEBC, or rather, whatever they were proposing to do was to reconstitute, not to restructure. They said the reason is they want to restructure, but they started reconstituting. And the manner in which they were doing it is that they were recommending a vetting process for the IEBC commissioners as they are. They never showed any minute that citizens asked that these commissioners be vetted. They never demonstrated that there was a necessity for that, and that the already provided provision in the Constitution had been attempted and failed. And thirdly, therefore it was not justified. It was not justified. And it is thinkable that the proposal was actually a bill of attainder, in the sense that it was really targeting these IEBC commissioners, because this was a cut and dry kind of exercise, that it will only apply to these particular ones, and after that the other provisions of the current constitutions will go on. And we thought that that was irrational and needed to be justified. We finally were asking for the use of public funds to be on a popular initiative. That is, once a popular initiative is begun, that public funds on public resources, not funds, public resources ought not to be used. However, we have to draw a distinction between public resources and public funds, because public resources include public funds, but public resources even include the portfolio, such that you cannot you cannot claim to be, rather, public resources include public funds, but public resources include the portfolio and include the bureaucratic machinery. And we were asking the court to declare that in a move to amend the Constitution by a popular initiative, public resources may not be used, including the public platform and whatnot. We demonstrated through a letter from the PS of Sports directing that signatures be collected, and that letter is found in volume 6, page 2444, directing that the junior staff facilitate the collection of signatures in support of the amendment, and that is use of public resources. It may not be use of public funds or public finances, but it is use of public resources, and that is not proper. The use of public resources may proceed even beyond the point of initiating, where the amendment has reached the level of a referendum. And being a political process, it should not really benefit from that. And there are reasons why a popular initiative should not be supported by public funds. One, a constitution is there for the control of government. If we are going to allow government to use public resources to pursue an amendment, then we will end up with a constitution that has been amended, or we will defeat the difficulty in amendment that is entrenched in our constitution. It defeats that inherent difficulty, and amendment is a political process. And if we are not going to allow public resources to be used when an individual is running for office, political office, to support their campaign, then we cannot support a political process like an amendment to the Constitution with public resources, because you will be disenfranchising and using part of the resources of those who even oppose that process without authority. And then what is good for the goose is good for the gander. Next time, if this time we are going to allow the government to use public resources to support or promote a popular initiative at any stage, then what we are doing, we are implicitly allowing it to oppose a popular initiative later. And that should not be allowed, because then it will beat the very essence of why we have a popular initiative. I wish to respond to the appeals, and I think I'm quite on time. I'll start with the basic structure doctrine and the unconstitutional, which is related to the doctrine of unconstitutional amendment. And I will simply define it majorly to the members of the public and members of our organization who are probably listening. That the basic structure doctrine is a judicial doctrine, which means it's a law. It's a judicial doctrine which grants review powers to a court, that judicial review power over the substance of an amendment on the basis that the amending authority has exceeded their power to amend by changing a fundamental part of the Constitution, where such a change amounts to replacing the Constitution. It is considered, yes.
Can you please tell us where that definition is from?
That is my understanding of the basic structure doctrine. And that's why I said I'll simplify it from what I have my reading and understanding of the basic structure doctrine. That a constitutional amendment happens, and it is procedural, However, the court is able to review the substance of the amendment on the basis that the amending authority lacks the capacity to amend, to cause such an amendment, because it is so fundamental it amounts to replacing the Constitution. Now, I put the substance, that is, it's a substantive review, in quotes, because I do not believe it's a substantive review, as the appellants have argued. Because once there is a procedure to amend, the procedure sort of precludes that the amending authority has capacity. There can be no proper procedure if there is no competence. So competence is actually part of the procedure. And the only reason the court is looking at the substance is to ascertain that the person who amended is competent. It is not looking to review or substitute its opinion with the substance of the amendment. It is really a procedural. Therefore, the question that it's not judiciable because it's a substantive review of an amendment, which is sort of a limitation of sovereign authority, I don't think that should be the case. What are the elements of this basic structure doctrine? One, it's judicial review power over, in quote unquote, the substance, and that the amending authority must be incapable of such an amendment, because they are not the ones who exercise constituent power, that is, the constitution making power. And usually there is no explicit limitation on the powers of the amending, the purported amending authority. Normally, the amending authority is incapable of such amendments because it's either, now in the context of our constitution, it would either be exercising delegated authority, purely delegated authority, or it would be exercising the indirect exercise of delegated power, that is by dint of the preamble. Because the preamble, as I read, the preamble tells us that it is the people who have the sovereign and inalienable right to determine the form of governance of our country, and having participated fully in the making of this constitution. Then what it means is that this particular authority, either it is not sovereign or it does not meet whatever the preamble tells us about the quality of the people when they are making the constitution. That is, they are sovereign, they are exercising their inalienable right, and have participated fully. Is the basic structure doctrine good law? We would look at it in form of the text and the application. And in form of the text, we would be asking ourselves, does it conform to the principles of our constitution? One, it seems on the face of it to be a limitation on amendment power, or to be a limitation on power that has been delegated, that is constituted power. And that is really the basis of constitutionalism. And therefore, from that view, it looks to be good law, because it is really promoting constitutionalism and whatnot. On the applicability of that law, or on the application of that law, we look at how it was applied in India and contrast it with how it was applied in the Ringera case that I think has been mentioned over and over during this appeal. In India, there is no express limitation to amendment power of parliament. There is no express limitation. And what the court did in Kesavananda and Minerva, and I think mainly Kesavananda and Minerva Mills, is that the court construed that itself it has the power to limit, and this is from the fact that there is a higher power and parliament is not that higher power, therefore it cannot destroy the constitution. And further, it defined the limitation. That is, it defined what amounts to the basic structure, because it is not defined in the Indian constitution. What this ended up doing, it created an inconsistency. And you will find even from the ruling, the judges themselves could not agree on what amounts to the basic structure. Even in Minerva Mills, when they had a similar matter, they still could not agree on what amounts to the basic structure. This created an inconsistency. The second thing is that it made the Supreme Court have unlimited power, because there was no standard of determining what is the basic structure. So a Supreme Court sitting today could decide this is the basic structure, and another one tomorrow could decide this is the basic structure. While the transfer, it looked like a limitation on parliamentary power to amend, but then it was actually transferring the exercise of sovereignty from parliament to the judiciary, because now the judiciary would be the one to determine what can constitute the basic structure and therefore is amendable, and what cannot, and when. Because if another court sits 10 years later, it would probably arrive at a different conclusion. And this is bad because it boils down the whole question of constitutional change to the opinion of a group of judges without a standard. And two, it is subjective and impermanent. And you can imagine an amendment passing today and a similar amendment 5 years later being questioned in court and failing. And that would mean that we would essentially be questioning the legitimacy of that previous amendment and whatnot. Therefore, to the extent that it created, it was making the court to become supreme because nobody could define and only the court could define what the basic structure is, it was actually, it would actually be deemed to be not promoting constitutionalism because it is just a transfer of power merely from parliament to the courts. The other thing is that the court said those parts are unamendable, absolutely. Why? Because the Indian constitution did not provide for, at least expressly, for the direct exercise of the constituent power by the people. And therefore, it practically made those unamendable. And to that extent, it extinguished the concept of sovereignty and transferred it to the court because it was now the court that would determine. In Kenya, on the other hand, Justice Ringera solved these two problems. And this is how Justice Ringera solved it. By providing for a referendum. By providing for a referendum, what the court was doing is it was limiting Parliament's power, but limiting its own power too, such that it was extinguishing the aspect of unamendability by recognizing that there is a sovereign and the sovereign can determine whether such things could be amended or not amended. And that is consistent with constitutionalism, that there is no delegated power that will have absolute power. The second thing is that where in the theory of delegation of authority, where the delegate finds that they are unable that they are unable to perform the task that has been delegated to them, the proper way to go about it is to refer it back to the delegator. And that is what the Ringera judgment was doing. At the time, we did not have a provision for the direct exercise of amendment power. And that meant that any exercise of sovereignty could be considered to be an exercise of constituent power. And I think that is why the referendum was the first thing, because at the time, the only exercise of sovereignty that seemed directly related to the constitution was the power of the people to vote. And I place myself in the position of Justice Ringera and the team, and by referring the issue to a referendum, it was the only exercise of sovereignty that was construable at the time. Therefore, the judicial review power was actually limited because now it was subject to a sovereign, although the judicial power could still determine what is a basic structure. But that power was limited because still an amendment can be done. And two, the sovereignty of the people was upheld and was not usurped. And this was because the people had not provided for a guide of how they will directly exercise their sovereignty within the constitution, at least their constituent power within the constitution. Now, the people in and this was happening, the context where this was happening was when we were trying to review the constitution, and up to the time when we got to the 2010 constitution, this was very much alive in the framers of the constitution, and therefore they could see the challenges that the basic structure as applied elsewhere had brought, and they could see the challenges that Justice Ringera team had in providing for whatever it had to provide. And therefore, while framing our constitution, Kenyans decided that they are going to define the basic structure, and they did so in Article 255. And from our submissions, you will see that I used the example of Article 10 to show that these things that comprise the basic structure in Article 255 have certain characteristics in them. And I agree with the advocate, Ian, who said that they are foundational, that you look at the Constitution and it's almost like they are there even before the Constitution. Secondly, they are cross-cutting. You look at the Constitution, you'll find them in Chapter 1, Chapter 2, Chapter 3, Chapter 6, Chapter 11. And thirdly, they are universal. The things in 255, you'll find them in multiple other constitutions. The 2010 Constitution recognized the challenges of the basic structure doctrine as applied and tried to solve them. Does it apply in Kenya? being a law that existed prior to the 2010 Constitution, Section 7 of the 6th Schedule tells us how a prior law can be considered as applicable in the country. And it tells us that it is applicable as long as it is construed in the manner that makes it consistent and conform to our Constitution. And so it is applicable with certain modifications. One, we have defined our basic structure in the Constitution. Therefore, judicial power does not have any authority to start redefining it, because we have expressly stated it there. Number two, there is the existence of a substantive limitation to parliamentary power. That is different from how it has traditionally been applied. Third, the constitutional supremacy is a limitation to judicial power. That while in India, or while prior, it could be applied that the judicial power could overlook the supremacy of the Constitution and declare and even attempt to adjudicate a power outside of the Constitution. The Constitution has declared that it is supreme. Therefore, you are not able to adjudicate over a power above the Constitution, and the court's eyes are limited to the supremacy of the Constitution. The people have declared their sovereignty, and they have provided for their direct exercise of this sovereignty in the Constitution. That therefore extinguishes the whole concept of unamendability or absolute unamendability, eternity clauses, because the people have provided. We own the sovereignty and we can exercise it directly. So the question that then comes up is the referendum the full manifestation of the people's sovereignty? And we'll compare this to the Ringera case. As I said, Justice Ringera and the team had no express guide to what constituted the constitutional sovereignty, or what constituted the sovereignty, and and any court that was established under a constitutional framework such as ours cannot really adjudicate on a power that is above the sovereignty, above the supremacy of the Constitution. If the Constitution tells you that this is the law that is supreme, then you cannot adjudicate over a law that is superior to that and still remain a court under that Constitution. That you may only recognize that there is a power above the Constitution, but then you may not adjudicate over how much of that power is adequate and whatnot. And that's what I was trying to say. And so even a referendum then would constitute a manifestation of sovereignty. And as I said, there are different levels of sovereignty. There is a greater sovereign and a lesser sovereign based on the capacity. So a referendum was a sovereign and could not be questioned at the time. And so that is what we did. Post 2010, the people have defined in the preamble the kind of sovereignty that is enough, if I should call it that, to make a constitution. And this sovereignty is in exercising our sovereign and inalienable right to determine, and so on and so forth, and having participated fully in the making of the Constitution. Therefore, the sovereignty required to make a constitution, which is making a constitution here is changing the Constitution in such a way that you're remaking it, is a sovereignty that has the most a robust participation of the people. And to that extent, I agree with the Superior Court. Therefore, the manifestation within the Constitution, because remember Article 1 has said that, Article 2, that the people can exercise their sovereignty directly. Under this Constitution, they can exercise it directly. Therefore, we will look for the direct exercise of sovereignty within the Constitution that gives us the most robust manifestation of participation, full participation of the people. And that will be the primary constituent power for us, because we can't look outside of the Constitution. There is an absurdity with the conflating a referendum with the primary constituent power, as the appellants would want us to believe. And this is it. A referendum is essentially a general election, only that it's an issue-based general election, because it's everybody participating, and there are a bit of minimum criteria required, but for all practical purposes, it's like the election of the president. So if we are saying that a referendum, merely a referendum, is what gives legitimacy to our Constitution, what that tells us is that in a case like our Constitution, which in the referendum garnered 66%, and in the last election, the president, I think, got 98%. Then it would mean the president has more legitimacy than that amendment or the Constitution itself. That cannot be it. Therefore, while the sovereignty involved in election of a president seems similar in that one of a referendum, the exercise of sovereignty that gives us the constitution is a greater sovereignty, if I should say that, is a greater one. And it's the other part of full participation that grants it that extra legitimacy. There is a downside to democracy, and I think I've attached in my bundle of authorities on page 75. There is a book titled Theories of Democracy by Cunningham. I forget the other name. And he talks about the inherent weaknesses of democracy. That is, democracy can be irrational. Democracy can actually be, it can hide a tyrannical rule by the majority. It can hide various other problems. And think, maybe let me just list them for the record. On page 75 of the bundle of authorities, that democracy can lead to an ineffective government, and he describes how it can. It can lead to a tyranny of the majority. It can lead to the massification of culture and morals. It can lead to conflict. It can lead to demagogy and the empty space of democracy. And the LSK chair talked about the rise of Adolf Hitler. It can mask oppressive rule. And so, and it can be irrational because people act on the spur of the moment. And those are inherent weaknesses of democracy that led us to actually found the idea of written constitutionalism. It was to check those inherent weaknesses of democracy. Of course, even the constitution cannot really itself limit democracy per se, but then democracy on realizing, or the people on realizing these inherent weaknesses of democracy, decided to pre-commit and guide their exercise of sovereignty. Not limit, but guide it for purposes of order and efficiency. And therefore, we cannot relegate a question like a constitutional question to be decided on a referendum, one referendum that is subject to all these weaknesses. There is an error in an extra-constitutional constituent power as advanced by the High Court. There are several errors that will make it inconsistent with our constitution. As I said, Article 1 provides that there is the direct exercise of sovereign power by the people, and this constitution has provided for it. Therefore, to construe an extra-constitutional exercise, what you'll be doing, you'll be disregarding Article 1. Number 2, Article 2 talks of the supremacy of the Constitution, but it also says that any claim to authority under this Constitution or any exercise of state authority must be authorized. Article 3, in defense of the Constitution, outlaws the establishment of any government outside of this Constitution, except as authorized under this Constitution. Therefore, to claim that we can set up a constitutional, sort of like an extra-constitutional framework to form another government would be unlawful in its very nature. Therefore, we can't do that under this Constitution. We cannot do that. No government entity, because the four-step process that the Superior Court suggested, civic education, public participation, constituent assembly, debates, and finally a referendum, would be organized in some way. They have to be organized. Who is this that will be organizing it? Is it Wanjiku? It has to be state machinery the way the 2010 Constitution was organized. And if it is state machinery, on what authority will they be doing that? What authority will they be using our taxes to organize that? What will have authorized that? Therefore, no government entity which exercises delegated authority under this Constitution can act except as authorized. So who will be doing this? Our courts are established within the context of this Constitution. They cannot adjudicate over an extra-constitutional exercise of sovereignty. What will be the standard through which the court will, if at all, through which a court will adjudicate over disputes relating to that exercise of sovereignty? The primary constituent power, therefore, has to be construed within the Constitution as it is, and in our view, it is contained in the popular initiative to amend. How? Here, all the state activity that happens within a popular initiative is tightly regulated. County assemblies can't change the document. Parliament cannot, in fact, Parliament cannot even veto it. And the IEBC is bound in how it will conduct and is limited anyway. Therefore, all their actions are subject to judicial review and they are bound by the Constitution. And the Constitution itself has provided for how these county assemblies will exercise their power as and still provided for public participation within it. The collection of 1 million signatures suggests an unenforceable but yet mandatory sort of like civic education, because you have to get 1 million registered voters to endorse that I have read, I have understood, and I support. And that will be verified by an independent body. That tells you that by the time you're getting 1 million registered voters as a Wanjiku or as a citizen and not the state, you will have really mandatorily had to go and spread the good message of the new constitution. Only the people can suggest a fundamental change to the delegating tool. That is, by a popular initiative, the government cannot be involved. Only the people. Therefore, it's a people process. The people themselves suggest. It goes for purposes of the Constituent Assembly. It may go to the county assemblies. And indeed, in France, their constitution was established by a Constituent Assembly, which served for the rest of the term as the National Assembly. Same to the South African story and many other places where a Constituent Assembly is the one, it's elected, and it's the one that, even in India, that acts as the National Assembly. Therefore, these people are already elected, and we have already provided the mechanism through which they can act as a Constituent Assembly. The National Assembly is a further Constituent Assembly with mandatory provisions in Article 118 for public participation. And then finally, we have a referendum. There is no other direct exercise of sovereign power within our Constitution that has this much participation of the people, where the people initiate and the people approve. Therefore, for all intents and purposes, this is what should be construed as the primary constituent power. But primary constituent power can also be exercised outside the Constitution. It's not mandatory that it has to be outside the Constitution. It is not bound by the Constitution, but it can still be exercised within the Constitution. And I think that is the one that our courts and any state organ has authority to adjudicate over. The use of Article 255 on parliamentary initiative, that's what you may ask. The parliamentary initiative also employs Article 255. What then is the remit of that? The remit of that is that there can be a change to the basic structure, and there can be a change of the basic structure. A change to the basic structure can be done by Parliament, but then they have to seek approval from the people in a referendum. A change of the basic structure, which now amounts to remaking the Constitution, has to go through the whole process of the popular initiative. Okay, I'll go to the remit of a popular initiative, and in the interest of time, I will, first of all, just answer a few questions. Did the president initiate the popular initiative? One, we cannot conflate proposing and initiation. Initiative, there are two in the Constitution, a parliamentary and a presidential initiative. Merely thinking about an amendment is not initiating. Merely proposing, if the president were working with the deputy president and proposed to them, I think we need a constitutional amendment, that's not an initiative. Therefore, I do not believe that the president, for as long as he is not the one who collected 1 million signatures and took them to IEBC, and the IEBC verified, then he did not initiate a popular initiative. He made proposals for an amendment, and we will, that's where we start. We have to distinguish the two. But then the president can only even make those proposals as authorized. And if there is no authority even to propose, or to propose it to the people, because we find authority in how the president can propose it to Parliament, can make that proposal to Parliament through the various opening of Parliament and the reports that he gives to Parliament. He can issue them with the report of the Building Bridges Task Force, and then a parliamentary initiative can be initiated. But there is no authority for how the president will initiate or will propose an amendment to the people. And nevertheless, was this a popular initiative? It may be considered a popular initiative, but from what has been gathered is that it was impure. It was the whole process was proposed by the state, and a popular initiative in its definition has to be done outside of the state, independent of the state by its definition, and you'll find that in my submissions and the authorities that I quoted in the submissions. Can it now become a popular initiative? No, it is already impure. It cannot be a popular initiative even now. The fact that it was proposed by the government. Can a state officer or president initiate a popular initiative with authority? Yes, and the only authority that can be given would be from the Constitution, not anywhere else, because the Constitution has only provided for 2. But then they can, in their private capacity. I reject the idea that the president loses rights when he becomes, personal rights when he becomes president. The president is also part of the people. And as long as he does it in his personal capacity, it's okay. He will face the same challenges as Wanjiku, as long as the state resources are not employed. Because when he does it in his private capacity, there are no state resources that will be employed. And therefore, he will have the very same difficulty that Wanjiku has. And if it's any easier for him, it's because he's already a politician and he's known. And that is a private advantage. It was not conferred by the presidency. In fact, he's president because he already had it. I want to go to the issue of IBC and quorum, and this relates to the supremacy of the Constitution. Supremacy of a law is both the text of the law, the purpose of the law, and the meaning of the law gives the law supremacy. Such that when we say the Constitution is supreme, it's both its purposes and the text. It's not just the text. Such that if there is any other law that in its application conflicts with the purpose of the Constitution, then that law will be invalid to that extent. And if we only look at text, we will get it wrong. A law is its purpose, and that's why I read for us Article 260, that the Constitution cannot have intended that a fully constituted commission cannot do the work that the Constitution intended. That once it has 3 commissioners, then the purpose for which it has been formed is to do a certain thing because it's fully constituted. Especially because we never provided that Parliament comes up with further legislation on that. Therefore, the Constitution intended that a fully constituted commission can function. However, Parliament in its wisdom made a law that was textually consistent, and that's fine. For in its application, it was consistent until when a constitutional duty calls. And now, IBC cannot perform a constitutional duty because Parliament imposed a limitation on it that the Constitution did not. Then the purpose of the Constitution will defeat the purpose of the Act. And that, for me, I submit that, one, the lack of quorum, if at all it is merely because of the legislative provision, cannot remove a constitutional imperative. On the issue of verifying an amendment, an and a is an indefinite article in English. An indefinite article meaning that it does not define. It can be one, it can be many. And an, actually, it is actually, if you check in the dictionary, Merriam-Webster dictionary, another definition of a and an when used as an indefinite article is any. And there are various places in the Constitution where the Constitution has said a, like a county assembly, a bill may be proposed in Parliament. That doesn't mean one bill. So we cannot restrict the fact that it said an amendment to mean one amendment. 2, what is the historical meaning of an amendment in Kenya? In Kenya, we have had amendments before, and they were framed as an amendment to the Constitution. And they were far-reaching, and they were accepted, and by the theory of recognition of law, they were recognized and practiced. And by the time we were writing an amendment to the Constitution may be proposed, we had that history. Our meaning of an amendment involved as far as it can go, as long as there is capacity to do that. Is an amendment the text, the issue, or the meaning? That's the third thing. If I were to, for instance, change the name of counties if I were to change the name of counties to Congress, if I were to propose such an amendment, we want to change the name of our counties to Congresses, county assemblies to Congresses, I would have to change so many parts of the Constitution. Would that constitute many amendments, or would it be one? And that is the Pandora's box that we open when we start dissecting the question of what is an amendment. I think it is an unnecessary limitation on the sovereignty of the people. And essentially because nothing stops anyone, any citizen, from starting their own amendment. Such that because there are no public resources used in the initiation, if at all there are no public resources used in the initiation, then nothing stops them from starting their own popular initiative and sorting out the things they don't want in the other initiative and putting the ones they want and then putting it to the people. Let's not unnecessarily limit someone who is not using public resources to do this thing, to propose this amendment. I want to talk about immunity, and I would Please ask that I be.
No, your time is up, Mr. Taiboso. You've done very well so far.
My Lord, I had already. I'll take 5 minutes. It's so important that I talk about this, my Lord.
No. I will request that you take a maximum of 2 minutes, precisely
Okay.
2.
There are instances in the Constitution where immunity is mentioned. One is the immunity of judges, commissioners, and that is Article 160, 259, 143, and Article 2. And there are only 2 instances where the immunity is immunity from proceedings. And that is Article 2 and the immunity of the president. That tells you that the immunity that the president enjoys is not the functional immunity like other officials. The president enjoys more than that. He enjoys sovereign immunity. And that has been there since 1963. We never changed it in the new constitution. The only thing we added was that, one, we now protect both the person and the people in and the person and the office itself from proceedings. If we were to go with what the court said is that we would defeat the purpose of even Article 143.3, and I think you will see that in my submission. And immunity is not impunity. There is impeachment, and at the end of the term, the president is actually liable and whatnot. On the issue of Chapter 6, Chapter 6 is very important because it is not a question of law. You can violate the law and still be an ethical person. And still on immunity, the president has power to interpret the Constitution. Anyone who applies the Constitution has to interpret it. So by saying that by the president violating the Constitution, he therefore loses immunity, it is to say that when the president exercises his function of interpreting the Constitution and interprets wrongly, he loses immunity. I think that is not right. The president wears 2 vests, one inside for functional immunity and the other one is outside, a cloak of sovereign immunity. And when he is president and performing the functions of president, he has the sovereign immunity. When he leaves that office, he may retain the functional immunity, which now is not immune to proceedings, and proceedings may go. I hope that answers Council Dudley's question, that the immunity the president has right now is immunity from proceedings. After that, he is immune from only liability, and that's different. Chapter 6 is a question of ethics, and we have established...
Dr.
My
Boso,
Lord, I had 5 seconds.
Also, your time is up. The last thing I want you to just tell Kenyans is, and you've done very well, by the way, thank you. You represent 254 Hope. Who is 254 Hope?
Oh, 254 Hope is an organization not registered, but it's an organization of young people, young professionals, doctors, lawyers, architects, and we have a few engineers and a few teachers. And what we are concerned with is we want to advance good governance in the country. We feel that the direction the country has been taking is wrong, and essentially what is going to happen is we'll be the ones who pay the price later on. So we decided to start organizing ourselves and hoping that we'll be able to change the country and put it in the right direction.
Okay, thank you very much. Thank you very much.
Thank you very much.
Done well. Thank you. Take your seat.
Honorable Judges, my name is Isaac Alwochir, petitioner in E426 of 2020. By profession, I'm on many things, but for today's purposes, I'll call myself an arbitrator. I recognize there are several of my seniors over here, Chartered Arbitrator Kamau Karori, Chartered Arbitrator Gido Muigai, Fellow Gatembu sitting on the bench, Eunice Lumalas, and a few others. So for today's purposes, I'll just use that. I'm going last amongst the respondents, so I'll try and make it my duty to try and also summarize some of the issues that we've covered. Because of the time constraints, my 45 minutes, I don't think I'll have time to go through my entire presentation. That's why I'm just using a summarized approach. Where points need to be highlighted, some issues need to be explained, I can insert some explanations or questions you've asked that haven't been fully answered. I'll try and insert them into those kind of slots. But I'll use the summary approach to guide me in the presentation. At the end of these proceedings, you'll come out with a judgment. In this judgment, I am looking to see some things in this judgment. And these are the things that I'm looking to see. Your findings, your holdings, which will determine the direction this country takes. The first thing I'm looking for is an affirmation that the Steering Committee on the Implementation of the Building Bridges to a United Kenya Task Force report was an unconstitutional and unlawful entity on account of having a constitutional change mandate that is reserved only to Parliament among publicly funded bodies pursuant to Article 94, Clause 3 and Article 256 of the Constitution. And I can even add Article 2, Clause 2 that Dr. Boso has just mentioned over here. And also, that steering committee was established in contravention of the mandatory provisions of Article 132, Clause 4A of the Constitution that requires the prior recommendation of the Public Service Commission before you establish such a body and appoint people to such a body. On these two grounds alone, everything that came out of the steering committee is unconstitutional, null, void, invalid.
Sorry, you said 132A?
132 Clause 4A.
Okay.
That requires the President to obtain the recommendation of the Public Service Commission before he can establish a public body and appoint people to it. He did not do that. That was unconstitutional. And therefore everything pursuant to Article 2 Clause 4 that he did is null, void, invalid. Everything the BBI Steering Committee did is null, void, and invalid. The report they produced, including Annex B, which included the Constitution of Kenya Amendment Bill 2020, is null and void, and that is almost word for word the very same bill that was presented for 1 million or 4 million signatures. The version that was printed by the government printer, dated 25th of November, is just a slightly edited version of the one that was contained in the report released by the BBI Steering Committee in October 2020 with the date of 30th June 2020. And you cannot tell me Dennis Waweru and Junet Mohammed authored the BBI bill when we can read what the steering committee in its report to the president gave, and you compare the two versions, the 30th June version and the 25th of November version, and almost word for word. If we are academicians over here, like Professor Gideon Muigai, try and do that when preparing your doctoral thesis. You'll be shot down for plagiarism. If anything, it was a criminal offense, that's exactly what would happen. So what we're having, what we're being told, is that some plagiarists in the name of Dennis Waweru and Junet Mohammed are the ones who are the authors of this bill. No deal. This thing was produced by the BBI Steering Committee because the president used an unconstitutional method to set it up. The whole process was unconstitutional from its establishment, and everything that came out of that entire process is null, void, and invalid. There's another reason that we also need to address based on the submissions by the appellants. They have tried to urge this court, don't look at issues prior to the collection of the 1 million signatures. Don't look at the establishment of the BBI Steering Committee in 3rd of January 2020, where the entire process starts with the unconstitutional purpose of that committee. Start looking at it from when Junet and Waweru came with the 1 million signatures to IEBC. I know that is wrong. I think it's been covered here by severally. We're dealing with a process, not an event. Nevertheless, I can oblige them by looking at Article 251, clauses 1, 2, 3, and 4. 1, 2, 3, and 10, which talks about an issue that has come here a few times. Are we dealing with a single amendment, or are we dealing with multiple amendments? I know even Dr. Bosa has tried to weigh in a little bit on that. To me, it's very clear. It talks about amendment in the singular, not in the plural. And yesterday's presentation by Counsel Esther Angawa showed the consistency between Article 257 and the referendum provisions in the Elections Act, where there's provision for singular or multiple amendments, etc. There are two distinct issues. But the trump card comes from Article 256. I think that one, is one worth referring to, because it's going to clarify a lot of issues that we've been dealing with over here. Article 256, Clause 1 reads, a bill to amend this constitution may be introduced in either House of Parliament, then B, may not address any other matter. That is singular. Or they want to deal with amendments or whatever, and it's not being a different article, that's neither here nor there. These are different phraseologies driving home the same point. It cannot deal with any other matter. It's dealing with a single matter. And if anybody thought the Constitution was confused about singular or multiple amendments, continue with the phrase, apart from consequential amendments, plural, to legislation. The only thing that can be appended to a singular amendment in a constitutional amendment bill is putting in subsidiary laws in the form of legislation that speak to the same issue, but not multiple issue amendments. And on that basis, this Constitution of Kenya Amendment Bill 2020 is dead on arrival. It has over 73 amendments proposals. The moment it came to IEBC, if IEBC was using this yardstick, Chapter 16, for verification purposes, it would have told Junet and Dennis, you've given us a bill that has 74 amendments, we can only deal with the bill with one amendment. If you want to bring 74 different amendments, go and get 74 lots of 1 million signatures out there in the country. Come here with over 74 million signatures. None of them did that. That is what we have here. I know we've spoken about both sides talking about the onerous nature of amending this constitution, but that is it. If you want to amend it, not replace it, amend it, one issue at a time, one matter at a time. Anything outside that matter is not to be considered. So therefore, the BBI bill is dead on arrival. In fact, we are wasting a lot of time here dealing with something that is a fake document. It's a legal phantom, a constitutional charade. And that is what the real two principles, Appellant Uhuru and Appellant Raila, have foisted on this nation, spending huge amounts of public funds, huge amount of national resources in our psyche, but giving us a fake document. It cannot pass a legal muster. Over 1 million people are signing their signatures, their names, to a fake document that has absolutely no value in the law of Kenya. And that is basically what has happened. And that is why some of us who are very unhappy with such fake things happening in this country had to come out from wherever we are. For me, I've come from Rongo. I was very busy doing my quiet issues of farming and maybe a small arbitration here and there. But when you see the country's foundational law being mutilated the way it was being mutilated, people trying to replace and overhaul the constitution, we have to come out and defend according to Article 3. There's an obligation on each and every single one of us to defend, respect, and uphold this constitution. And that is exactly what we're doing. And I commend 254 Hope and Dr. Boso for also taking that role, coming in on our own. We're not paid by some whoever. We're just Kenyans who love this country. And we want to defend this country from the sharks who want to mutilate it. And that is why we are here. I'll proceed with my presentation. So therefore, the one thing, it should be very clear, we do not have a popular initiative. Popular initiative is defined in Articles 255, 1 and 2. It is either a draft bill or a general suggestion that is supported by at least 1 million registered voters. What we have here is a bill with multiple amendments, but according to the Chapter 16, that bill should have only one amendment. So it doesn't pass that particular test, so we do not have a popular initiative put before the nation over here. We're wasting time talking about something that doesn't even exist. So it is for this court to strike out this particular issue, and it be a lesson to anybody thinking of bringing an amendment in the future to this constitution, not to waste anybody's time. It's time for this court to assert its independence and assert its authority, which we the people delegated to you. You're basically asking you to do your job. Now there are issues, disputes whether it was Junet, Mohammed, and Dennis Waweru who are the real promoters. I will suggest that Junet and Dennis actually fit into the definition of a promoter. Because if you look at, I think, Article 257.4, whoever presents the bill and the signatures to IEBC is termed as a promoter. And therefore, by that definition, Junet and Dennis, since they're the ones who presented the bill, they are promoters. But if you also look at Article 2, Clause 3 of that article, whoever formulates the general suggestion into a draft bill is also a promoter. And the person who formulated, or the people who formulated the draft bill, was this BBI steering committee. And therefore, the Superior Court was not wrong to refer to the BBI steering committee as a promoter of this process. They're defined in the Constitution as a promoter. Dennis and Jeanette are also defined in the Constitution as a promoter. So we have promoters in plural, which is basically what is provided for in 257. So they're all promoters. And if you go to the organization that appended its signature to the bill on 25th of November 2020, they just said, Building Bridges Initiative, published by the government printer, printed by the government printer Nairobi. They didn't even tell us who's Building Bridges Initiative. We don't know whether it's Junet, we don't know whether it's BBI steering committee, we don't know whether it's appellant Uhuru or appellant Raila, we don't know. It is not defined, but it doesn't really matter. Promoters is plural, and therefore, when you make a finding, since the appellants are trying to bring this issue, we're dealing with a body that died in 30th of June 2020, despite the fact it was alive, giving letters to the president on 16th of October 2020, being present in person in the ceremonies and everything else. I would suggest that maybe the particular finding and declaration of the court can be altered to something like, a declaration is hereby made that the entire unconstitutional constitutional change process promoted by the steering committee on the implementation of the Building Bridges to a United Kenya Task Force report, by the Building Bridges Initiative, and by the Building Bridges to a United Kenya National Secretariat is unconstitutional, null, and void. In other words, yes, we can change a little bit factual issues to incorporate the additional promoters, but it will not change the effect. The whole bill is still a nullity. It's invalid, and there's effectively no change to the orders of the Superior Court. Now that is the general point which I wanted to deal with, because that is basically why we're here. There's this bill, we're being told, give the people the sovereign authority, let them decide on this thing. But the people cannot decide on a fake document. Let them bring a proper document, and the people can decide on that proper document, but not on fakes, no. I will now turn now to deal with the Kenyatta appeal. They basically came here with a partial appeal, basically attacking my petition in the Superior Court. So therefore, let me turn my attention to addressing the issues that they dealt with, the issues that they raised. The first primary issue that they raised is that appellant Kenyatta was not served. Amongst my bundle of documents is a supplementary record of appeal dated 8th of June, a very tiny document, which basically is the affidavit of service dated 16th of January 2020, received by the court, date stamped 18th of January 2020, enclosing the email that were used for serving the president and the other parties. It wasn't just him alone. Other parties were also served. The other parties received everything. There was no email bouncing, email returning. The email address doesn't work. And I didn't stop there. In the e-filing judiciary system, there's also a provision when you're lodging documents to request for service by the court. I also requested for that service by the court and paid for it. And after some days, because of the time the petition was filed was 21st of December, before the end of the year, they hadn't effected service, but once they came back in the new year, they effected service and they recorded it served, including the appellant Kenyatta and other parties who were also served. So there was two forms of service, one by myself by email, one by the court. So when the president's team comes here and says that he was not served and they submit on the law, fine, their submissions on the law are correct.
So just a minute, can you see that, clerk?
It's a very tiny one.
Can you see that? No, you have there.
You got a copy. If you don't, you can have mine for now. It's a very tiny document, very thin, just one.
All right, thank you.
Yes.
Please proceed, but we'll give it back to you.
No problem. So that's basically just to prove all of their case based on non-service is all null and void. But this issue of service now raises an issue, because appellant Uhuru is known to be one, when he has an opportunity of evading service, he does evade service. There is a case that is cited in my list of authorities, and President Musinga and Justice Gatembo, I know you dealt with it, which was the issue Kenya Human Rights and another versus AG and 6 others, 2019 case, EKLR, which also involved, the International Center for Policy and Conflict. The case came from the High Court just before the elections of 2013. And at that time, basically, they were trying to serve parties, including Uhuru and Ruto, and they were having a difficult time until they managed to get a very resourceful process server, who eventually were in a political rally somewhere in Machakos or thereabouts. As they were coming from the podium, before they got into the vehicles, he had a cameraman ready with him, video camera, photographic camera, and they served them. Now, that showed how extremely difficult it was to serve appellant Uhuru at the time. But they succeeded, and the case went ahead and eventually reached a level at the Court of Appeal. Again, in the media the other day, while the president was touring, he was in the company of one senior counsel, Senator Orengo, and he was saying, watanipata wapi wanipatie makaratasi zao za kotini, watanipata wapi? Of course, if you go and barricade yourself in State House, an ordinary Kenyan like myself, I cannot penetrate, the security is going to stop me. And this is basically what happened. Again, Senator Orengo was involved in that particular case, whereby he was, I believe he was representing retired President Mwai Kibaki, and was suing in a presidential election petition former President Moi. And of course, Kibaki could not serve Moi. Moi was barricaded in State House. And that was, when he came to the court, things didn't work out, and it was dismissed on technicality for failure of service. I know a former president of this court had a very hard time trying to explain how he arrived at that particular decision he made when he was trying to be interviewed for the Supreme Court Chief of Justice. In other words, what I'm saying, we have enough examples of things not having been done right in the past. It is time to do things right. We are coming from the days of darkness. Our senior counsel Hamin told us in the morning, the history of this country is terrible. Maybe some of the young ones don't remember, but we're coming from a terrible history. These are some of the things that are happening in those bad days. Appellant Uhuru is trying to turn us back to those dark days we came from. We chose for ourselves the Constitution 2010. And in the Constitution 2010, when it comes to service, we have Article 87 Clause 3, which deals with service of presidential election petitions and other petitions, which provides for both direct service and indirect service. Indirect can be by adverts in a national newspaper. And that was basically to deal with the mischief of presidents barricading themselves in State House so that you could not serve them. And that is how we, the people of Kenya, decided to deal with that. And bringing in Article 259, on purposive interpretation of this Constitution, when you place an advert in a newspaper, there is no guarantee the person who is being served via the newspaper will actually have read that particular advert. If they don't buy that newspaper, they won't read it. The only thing is that the information is made available to them. They can, if they buy the newspaper, they can read it, somebody might see it and inform them. But the issue in our Constitution is to make available information on a court process available to the person who is a party to court, that they may have the opportunity of answering to that particular scenario. So once you've been informed indirectly, say by a newspaper, even if you don't see the ad, and maybe your cousin somewhere half around the country sees it and calls you, what is happening? I'm seeing your name in the newspaper. Once you have that information, you go to court and deal with the matter. And this is basically what we decided in 2010 to deal with the mischief of parties who were basically playing hardball when it comes to service and then trying to rely on the technicality. I wasn't served, the rules of natural justice were not followed, I wasn't given a fair hearing, I'm not being treated equally, the court is unfair to me, all sorts of stories. The Superior Court was not unfair to appellant Kenyatta. The Superior Court had that particular affidavit on file. They knew this person was served twice, one by the court and one by the petitioner. So they were satisfied, we can proceed ahead. Even when they asked the AG, are you here representing Uhuru? And the counsel for the AG would say, no, we are here as AG because we're a party in this particular petition. Even though they went to argue the case, I didn't make any noise because I wanted his voice, whether directly or indirectly, to be heard. I didn't want to shut him out. I know when I had another issue with appellant Uhuru, petition 360 of 2013, this time he was served via Harambee House, office via Harambee House. Surprise, surprise, when he comes to the court in the High Court, he doesn't send his advocates. The advocates who came were AG Githu Muigai's people. Those are the ones who came to represent him on that particular day. AG was not a party, but they came. I mean, all sorts of arguments such as even Clarence is talking about over here. Oh, the president is sovereign. There's no difference between the president and the presidency is one and the same. All sorts of stories. Fortunately, Honorable Justice Lenaola saw through the argument and basically shut them out from that particular. They were not parties to the case. They didn't even have a notice of appointment from anybody. They were not complying with the Article 56 provisions of the Constitution concerning their mandate in the Constitution, and they were kicked out of that particular case. After they were kicked out of that particular case, Appellant Uhuru appointed now Solicitor General Kennedy Ogeto, then in private practice, as his lawyer, and then we proceeded with the matter in that particular fashion. So Appellant Uhuru knows these things. It's not that he doesn't know. He knows these things. It's just that he plays hardball. That is basically what he's doing. So I'm not surprised that he's behaving the same way in this particular matter.
That is which matter, and is it
petition? Now, I just made a reference to it, I think probably in my, maybe in my documentation, because, no, in the lower court, not in this one, not in my submissions here, but petition 360, Isaac Aluoch Polo Aluochir versus Uhuru Muigai Kenyatta and William Samoei Ruto, 2014 EKLR.
That is a different matter, not this one.
Not this matter. Okay. I'm giving example. This is, okay. I mean, we've dealt with one another before. I mean, in court, we've met in court before. So I'm just telling you, I'm not surprised that he's behaving this way in this matter, because that's his nature. So any issue by the appellant Uhuru that I abandoned my petition because I didn't serve him, all null and void. He was served. I didn't abandon my petition. I prosecuted to the very end and got the orders against him. Now the issue also arises, was Appellant Uhuru acting in his personal capacity or in his official capacity when he established the BBI steering committee? He said in the Gazette notice that he was acting in his official capacity, signing it as President and Commander-in-Chief of the Kenya Defense Forces. But what he was doing was not part of his mandate as President of Kenya. There is no authority granted by the Constitution for the President to establish an organization or an entity that deals with constitutional change. That is the mandate of Parliament. He was acting beyond his jurisdiction. He did not have jurisdiction, devoid of his jurisdiction. Consequently, he was not performing official presidential functions. He was performing his own private business, the business of trying to change or overhaul the Constitution of Kenya without authority from the Constitution. Therefore, he was not acting in his official capacity. Despite purporting to do so, he was acting in his own personal or private capacity. And that is why I sued him in his private capacity. That's why I sued Uhuru Muigai Kenyatta, not President of the Republic of Kenya. Consequently, because he purported to act as President of the Republic of Kenya, using the authority of the state of office of President of the Republic of Kenya, contravening Article 2.2 that prevents anybody from exercising state authority unless you have authority under the Constitution. He was basically abusing his office. And that abuse of office is a contravention of Chapter 6, Article 73, Clause 1A, Roman 1. And that is why I sought that particular declaration against him. And it is not the first time that these courts have found declarations of contraventions of Chapter 6 against Appellant Uhuru. The very first time it happened was in 2012. Those days used to be chairman of KANU. 4 KANU members got tired of KANU's inactivity. So they took him to court in Mombasa. I believe that is Mombasa Constitutional Petition number 17 of 2010, 2 months after the promulgation of the Constitution. Eventually, a decision came around October 2012, and Uhuru was found to have contravened Chapter 6, specifically Article 77, Clause 2, being an appointed state officer and holding office in a political party. He refused to resign his office in KANU, and he remained the Deputy Prime Minister, Minister for Finance. Those are appointive offices, and therefore he contravened Chapter 6. And there is a Chapter 6 contravention, holding against Uhuru, Appellant Uhuru even today. This issue was even raised to IEBC before the 2013 general election. IEBC just ignored them. Maybe they fear dealing with Appellant Uhuru or whatever. And so Appellant Uhuru is now president, though if the law had been followed, Uhuru would never have been president, because that finding of Chapter 6, which he never appealed even to date, how many years down the road? 9 years down the road, he's never appealed it. It's a valid Chapter 6 finding against him. So one wonders, why is he making so much noise about a Chapter 6 finding against him, this BBI issue, when there's already an existing Chapter 6 finding against him, in that case from Mombasa, and another Chapter 6 finding against him in my case in 2016, the one that I referred to earlier on. So I'm just wondering why it's making so much noise. Maybe those ones didn't have the high profile. And this one, because BBI, everybody in the country knew something was happening, he decided, no, too many people know about it, I'll come and defend myself. But my point is, whether or not the finding of, on Chapter 6 in this particular matter is changed or not, there are still 2 existing Chapter 6 findings against him, and despite that, because he has contempt for this Katiba, he's still president, and nobody's doing anything about it. That is the state of Kenya, contempt of the Constitution by Appellant Uhuru. And this is the thing that some of us don't like. And I think something we need to get clear over here. Appellant Uhuru is not the sovereign of this country. We, the people, are the sovereigns of this country. Issues of doctrines are not sovereign immunity. Those sovereign immunity doctrines do not apply to Kenya. If sovereign immunity doctrine applied to Kenya, there'd be no court. Because I am the sovereign, you can't sue me. And you as the sovereign, I can't sue you. Nobody could sue anybody else. The dispute resolution business would be dead. Because all of us would have sovereign immunity, because we're the sovereigns of Kenya. So don't tell us Uhuru is a sovereign of this country. No, apparently he's not sovereign of this country. He is a subject of us, the sovereigns. We're the ones paying his salary. We're the ones appointing him. We're the ones delegating our power to him. He is our employee. Maybe the most senior employee, but still our employee. And when he goes off the rails, we come here to discipline him. Therefore, when you're talking about a declaration against him, that is just to discipline him. It's a slap on the wrist. We haven't yet kicked him out of office, but at least we're disciplining him. There you've gone overboard, our employee. Employee number 1, Appellant Uhuru, you've gone overboard. And that is basically, that's what we're doing over here. So we don't want any nonsense being told he's sovereign, sovereign immunity. Outside Kenya, because of diplomatic conventions, we don't mind, he can ride with sovereign immunity. But here at home, he must know that we are the sovereigns, he is a servant of ours. And he must do what we agreed to do in the Katiba. And that is basically what we're fighting for over here. And now come to these issues of immunity. There's a wonderful case which sets the law in Kenya on presidential immunity. It is most unfortunate that it hasn't been publicized. It's been around for 2 years. Honorable Justice Musinga, you were the president of that Court of Appeal bench. Honorable Justice Gatembo, you were there as another member of that bench. Honorable Lady Justice Agnes Murkol was a third member of that bench. There is no higher court that has looked into this matter of presidential immunity that has come with very clear, precise, well-researched findings and determinations than that particular case of yours. Kenya Human Rights Commission and another versus the AG and 6 others, 2019 EKLR. That establishes the law on presidential immunity in Kenya. It is unfortunate that at the time we're in the High Court, we want that resourceful to have informed the Superior Court of that particular authority. But now we've come here, we've kind of upped our game a bit, and now we're citing that particular authority. That is the law in Kenya. There is nothing like absolute immunity. We had absolute immunity in the retired constitution. You could not institute or maintain a cause of action in a court in Kenya against the president at the time on criminal matters, and when it came to civil matters, provided you wanted some relief, you couldn't institute any court action. We changed that specifically. In Article 43, Clause 4, you can sue the president for criminal misconduct. If he commits a crime, you can sue him, provided the matter has been covered by an international treaty to which Kenya is a signatory. In other words, he does not have absolute criminal immunity. He doesn't. If he commits a crime that falls under the category of Article 43, Clause 4, we can take him to court. Under Article 43, Clause 2, it is very clear. Functional immunity is what he has, in common with other state officers in different functions of public service. That's what he has. If he's performing a function of office, we can't sue him. And I gave the example, which I think is apt, because a lot of noise has been made in Kenya about it, concerning judges. It is his official duty to appoint judges. That's an official function of presidential office. 2 years went by, he refused to appoint them. In such a case, because it was an action or omission on an official function, you could take him nowhere. You couldn't sue him. You can't institute a civil suit against him. Take him nowhere. There, he had immunity. But when he goes beyond his jurisdiction, in setting up BBI steering committee, when he has no power to so set up a committee, with a constitutional change function, he's acting beyond the protective cover of functional office. Then it's fair game. That's why I sued him. That's why I'm here. So issues of absolute immunity, that's null and void. This court established the state of law in Kenya on that issue, and I would encourage everybody who wants to enhance their knowledge of that issue to please refer to that court. Very well researched, very well argued judgment, and I commend it to everyone here. Another issue that has come up, we've been told a lot of stories that, we're treating Appellant Uhuru very unfairly, we're infringing upon his political rights under Article 38, his equality rights under Article 27, his freedom of expression rights under Article 23, by trying to place restrictions on him while he's president. He's also a human being. He has human rights just like everybody else has human rights and fundamental freedoms under the Bill of Rights. I raised the issue of Article 24, limitations on those human rights. And of course, the senior counsel on the other side latched on it very quickly. That particular provision says those rights can be limited by national legislation. But I'm not referring to limitations by the national legislation. I'm referring to limitation by the Constitution itself in the form of Chapter 6. You're all state officers. You're not allowed to have a bank account in a foreign country unless you get specific approval from ESCC. That's a limitation on your freedom. Where to possess your property, it's a limitation. It's applicable to all state officers. If you're an appointed state officer, you're not allowed to become an official of a political party. Article 77, Clause 2. That's a limitation on your rights, a limitation on your Article 38 political rights. When you agreed to become a state officer, you knew those were the limitations on your rights that were imposed by working in that particular office. You made a conscious decision, a conscious choice. I agree to limit my rights in these particular areas so that I can serve the people of Kenya in this particular state office. That is exactly what Uhuru did. Appellant Uhuru, when he agreed to serve in presidential office as president, some of his rights that he has common with everybody else, he agreed to have them limited by the provisions of Chapter 6. And therefore, his people shouldn't come here and tell us, we're infringing on his rights. We're infringing on nobody's rights. It was his own choice, a conscious decision. And he took the oath to uphold, obey, respect, safeguard, protect this Constitution. Yet when it comes down to the reality, he doesn't want to live it. In fact, it's very sad to say this, but our president is not the best example when it comes to constitutional compliance. It's a very sad tale. And it's also very sad that our parliament, which has some authority in disciplining him, actually doesn't bother to discipline him. But that's just the reality of the situation we have over here. And therefore, we are forced, some of us who are private citizens, to come and try and defend the Constitution. Yet we have parliamentarians who are paying hefty salaries every month who are supposed to be doing such a job, but they're not doing that job. That's the sad state of Kenya today. Consequently, Appellant Uhuru has basically contravened Chapter 6, not just Article 73, 1A. In my submissions, I also show how he has contravened Article 73, 2B, and also Article 75, 1. I know I did seek declarations for those ones in the Superior Court. We just wanted to drive home a message. Just get one simple one to kind of discipline him a bit. Tap on the wrist, a slap on the wrist, just to bring him back to behave properly. We weren't seeking to get him kicked out. If you wanted to get him kicked out, we can go to try and persuade Parliament to impeach him and all that. But we just wanted to drive home the point. Appellant Uhuru, the president of this country, please obey the law. Stop disregarding this Gotv of ours, especially when you're the #1 citizen of this country. You took the oath to obey, respect, uphold, and defend this Constitution of Kenya, and you're not doing it. Instead, you're the one out leading the process of amending and tearing apart this Gotv of ours. It is not on. And these are some of the things that annoyed me as a Kenyan, especially in the Jamhuri Day speech last year, when he totally tore the Katiba. And I was wondering, is it right to use a national day for Jamhuri Day? A whole president tearing apart the Katiba. That is why a few days later, I filed this particular petition. I was annoyed. He annoyed me. And that is why I'm here. Yeah, that's why I'm here. We've also been told a story. When Appellant Uhuru was setting up the BBI thing, he was pursuing national unity, We've got the provision of Article 131, Clause 2C, where he has a duty, official duty to pursue national unity. Yes, I accept that. In fact, I encourage him to do that. In fact, I was very happy when he reached a deal with Appellant Raila to end the electoral violence, because this process basically began from post-election violence that we're now basically playing out over here. That's where it actually started. And then with the deal between the two of them, then comes the Gazette Notice, BBI Task Force, which doesn't have a constitutional change mandate. Again, he made a mistake there. He didn't consult the Public Service Commission. If I was Judge Mativo, I would have said it's unconstitutional because he didn't consult the Public Service Commission. He broke Article 132, 4A. But Mativo didn't talk about that, and therefore it passed through the court. And that is what is being used here as supposed to be the basis of res judicata. Yet it's a wrong decision. We cannot use a wrong decision. Fortunately, you're an appellate court. You're not bound by the findings of the High Court. You make your own independent decision. And I'm sure you will. And you'll be faithful to the law. But anyway, what we're being told is that we should allow Uhuru to set up, Appellant Uhuru, the BBI Steering Committee, because he's pursuing national unity. Where did we allow the president to break the law, to purportedly obey the law? I mean, in which country do you break the law to obey the law? Where? He should have been faithful to the law of setting up the BBI Steering Committee without a constitutional change mandate and seeking and respecting the authority of the Public Service Commission, getting the recommendation and doing things properly. If he did things properly, he'll be legally compliant and he'll be pursuing the national unity objective under Article 131, 2A. And that will be fine. I won't have any issue with him on such a scenario. But he went about it the wrong way. And so we say, don't break the law to purportedly obey the law. On res judicata, the other side has cited a lot of the case, the Third Way Alliance, and another versus Head of Public Service, Joseph Kinyo, and two others, as being the basis of res judicata. I won't spend too much time on it because Counsel Elias Mutuma yesterday dealt with it very ably. The parties are not the same. One is BBI Task Force, one is BBI Steering Committee. Task Force had no constitutional change mandate, Steering Committee had a constitutional change mandate. Therefore, res judicata doesn't apply. So those are just red herrings to waste our time here in court. But there's one good thing that came out from that case, not a ratio decision, but an obiter dicta comment by Judge Mativo, where basically he spoke to the basic structure doctrine, and I think you might want to have a look at it just to check his comments. He acknowledged we do have a basic structure in the Constitution, and he also highlighted what he called the Great Commandment of Constitutional Interpretation, Article 259. I thought those issues were good things from that judgment. So let nobody think that I'm against Justice Mativo. No, not really. It's just that he failed to consider Article 132 4A, the requirement to consult the Public Service Commission in setting up a body with respect to BBI Task Force. But otherwise, the obiter aspects of his judgment were pretty good, and I was very happy with them. Now, there's some other issues that are raised in my petition, which the court denied, which is basically Article 226, Clause 5. That imposes a personal financial liability on anybody who causes the loss of public funds on account of breaking the law or acting without authority. Now we'll ask for a prayer that Appellant Uhuru be found personally liable for all of the expenses of the unconstitutional BBI Steering Committee and the entire process up to the point of that reach over here. Now the lower court actually used a technicality, not quite a technicality, but it is an opportunity to dodge issuing that very difficult and tough decision which would have set the standard for this country. They said because we had asked that the Auditor General compute the figures, they said correctly, Auditor General is an independent office, we can't order the Auditor General around and everything else, therefore we're not going to grant you your prayers. But we agree with you, Article 2265 is valid, etc., etc., etc. Now in our prayers, we'd also ask for any other just order. Surely it was in the power of the lower court to remove the Auditor General bit and issue an order affirming Article 226, Clause 5. So that this nation knows, all public servants who are looting this country dry know when they break the law, they are going to have to refund all this money. Moreover, more cases across the appeal on this particular issue as concerns Appellant Uhuru. I am asking you to affirm that particular cross appeal, and you make the finding that appellant to Uhuru should reimburse the National Treasury for all of the illegally used funds in the unconstitutional and illegal, null, void, and invalid body called the BBI Steering Committee, and everything else that has proceeded subsequently. We'd also ask for another similar order, that other public officers be found to be similarly liable, and that the AG over here should be the one to do that job and ensure that all those people who are also responsible do that. If you use your discretion under the Rule 31 of the Court of Appeal rules, you can apply that. I know Advocate Kanjama in his impugned appeal had also asked for that, but since you struck out the appeal, that one seems to have gone by the wayside. But you have your discretion, so you know what to bring in and what not to bring in. A lot has been said about the basic structure doctrine. I don't want to talk too much about it. I did submit on it in the Superior Court, and there are references in my submissions to that. You might want to have a look at it and everything else. I will very freely admit some of the deeper thought analysis from some of the parties over here are better than those particular submissions of mine, so you can rely on the others. I freely admit that. Now, coming up to wrapping up some of the issues over here, I see with the time left, some of the issues that I wanted to thrash out, I will thrash out. I mean, there are several questions that were raised. I mean, those will just disappear. We'll just now force you guys to use your intellect and judgment to wade through them. We can't help you on those ones. But it is my general observation that the Kenyatta appeal dealt largely with procedural technicalities and attempted to elevate these procedural technicalities above substantive justice, contrary to Article 159, Clause 2D of the Katiba. Its approach is also duplicitous, arguing the law not based on facts, as should be the case, but based on fiction. Matters they introduce and then they argue the law based on fiction. We are here in a court of law, not a court of fiction. We use facts to arrive at determinations, not fiction. I therefore urge you to disregard all their fictions. Let's use fact and come up to correct findings, both of fact and of law. I mean, I'll give myself an example. When I found out by checking the law that Junet and Waweru could actually qualify as promoters, I've readily admitted it. I've taken a position slightly different from some of my fellow respondents, because Clause 4 of Article 57 includes them under promoters, but they were not the only promoters. It was them, steering committee, and another one undefined BBI, according to the published bill. So same thing should apply to them. They should learn to use facts, not fiction. I therefore basically humbly pray that you dismiss all these appeals that are based on the issues that I've covered. There might be a few tweaks here and there. You might be amending some of the orders of the High Court here and there because you're an appellate court, you're reviewing everything. I understand that. But in essence, the Constitution of Kenya Amendment Bill 2020 is an invalid popular initiative. It's null and void, dead on arrival. That one is finished. The main reason why we're here is that particular bill. That one is completely finished. If they want to appeal and take us to the Supreme Court, tunawangoja huko, no problem. We'll meet up there, no problem. But in terms of proper jurisdiction, I mean, they shouldn't waste anybody else's time. This thing should end at this appellate level. And if they want to change the Constitution, let them follow the proper procedure. One amendment at a time. Don't bring us multiple amendments. One amendment, one bill containing one amendment. If it contains anything about the amendment to the Constitution, it should only be amendments, plural, on national legislation that are affected by the amendment to the Constitution, but not anything else. I have an apology to make to my fellow respondents. Time has cut me out. I can't address all the other issues that were left out that should have been addressed. I also haven't addressed 2/3 of my presentation because I was supposed to have 2 hours. I was only given 45 minutes. And therefore, that's just the way things are. But generally, I thank you for your time, and I pray that you do the job that Kenyans put in those offices to do. Uphold, respect, defend this Katiba of ours, and don't let anybody, especially a mere employee of ours, employee number one, he's just an employee of ours, don't let him write roughshod over us. We are the sovereigns. We are the people, and therefore he must obey and follow our law. Thank you very much.
Thank you, Mr. Alochia. We now move on to the appellants. You have 15 minutes each to make your response. Sorry. Yeah. Let's take a 10-minute break, and then when you come, the appellants be ready to make your quick responses.
This conference is no longer being recorded.
Why crocodile inaweza tokea juu. Hiyo sijakula hata unataka nikufe kabla ni. I don't like it. I don't. Miss Kai na hipo ikitokelezea ivuruge. No, ni sawa. Those who know me will tell you I'm not a lover of large volumes of water. But for you, we rove the different parts of the country and beyond just to make sure that we bring you the experience. We educate you, we entertain you, and we inform you.
That it's not political and it can do something.
As we sail, you, entertain you, and invite to Friday only on TV.
Excuse me?
Just 5 shillings.
5 shillings? Just 5 shillings? It all begins with just 5 shillings, whether it's the Juakali industry.
Every challenge.
Yeah. Bike your business, just start. Or the art industry. It's not entirely, it's not about the money, it's what you do with the money. This and much more on the grind to have a profitable day. With me, Violet Njoki, every Monday at 7:30 p.m.
Woo. Construction can be quite a task, but how do you move from finding your piece of land, sourcing the right materials, getting the right labor force to put up your building? Or better yet, how do you source for a building that's already built?
Just a small size of land can suit just a big maisonette because you are good.
How do you ensure you get the right finishes to bring out the aesthetic value of your property and make it not only look good but also feel good?
The buyer to pay cash.
Well, we have it right here on The Realtor on TV47, where we demand industry for you to take advantage when acquiring your next piece of property.
Save a Life ni shirika la kijamii ambalo linakuletea hadithi za kuhamasisha ili kubadilisha na kuokoa matibabu wale ambao hawajiwezi na mafunzo ya vyombo vya habari. Jumuika nasi hapa kila wiki tukikuletea hadithi hizi za kuhamasisha.
Service to humanity is service to God. Save a life. Transform a life.
A vigorous soap opera about two lovers fighting against their relentless fate, which opposes them in the heist of murder, lies, betrayal, and secrets of those who claim to love them. Sylvia and Bruno Alvarado will do whatever it takes to get rid of anyone who interferes with their plans. The paths of Maya and Alberto cross under a devastating storm. Right there between the tempest, a love that will provide a strong reason to go on will arise.
Me llamo Mía. Le voy a dar algo. Para que lo cuide. De veras que le hace falta.
Me llamo Alberto.
Oriana Roldan is between Maya and Alberto, a renowned bullfighter with a psychotic personality, willing to do anything to regain Alberto's love.
¡Te estoy hablando! Mía, niña, suéltame, mi hermano, no, Mía, te estoy hablando.
So much love. Monday on TV 47.
Every February, we hear men joking about going to a men's conference on Valentine's Day. We laugh about it, the lucky ones end up having a decent Valentine's Day, and we move on. But what we do not know is that men actually do meet up. Men do sit down and have things that affect their day-to-day life.
Let me ask, does money make the man?
Give them the gifts, shower them with everything you want to shower them with, but keep your money to yourself.
I, for one, have always been curious as to what goes on in a man's mind, specifically an alpha male's mind.
Adam, yule kwa Biblia anasema ni mtu wa kwanza duniani. Wewe unadhani kama angekuwa hana yale matunda, hana ile garden yake pale ya kukaa, angekuwa tu ni mdomo tu anamfuata Hawa. Oya, mimi ni Adam.
Welcome to the men's conference, where we make men alpha males, the only female allowed at the conference.
Whoa.
Relax. I'm just you from the future. And speaking about the future, do you know what's coming up on Tech 47? No, I wouldn't know. How would I anyway? Oh, you don't know? Huh. Take a look. I mean.
Access granted.
I know, right? Wow. And remember, if you don't see it on Tech 47, then it technically did not happen.
From your Juma Sala to the comfort of your living room.
Usiseme mama yuko katika maisha ya analog, wewe uko katika masala la digital era.
We play you local, international and freshener shades to warm your heart. We also engage you with enlightening discussions with a din perspective to boost you.
Iko chini ya nyayo za kina mama. Kwa hivyo inamaanisha mama ni pepo yenyewe, baba ni mlango wa pepo.
Tune in to An-Nur with me, Halima binti Omar. We are your
Hey kids, welcome to Kids on the Block. Every Saturday we give you entertainment and education all in one. From science, art world, storytelling and fun time. We play, dance and learn all in one day. Join us every Saturday and don't miss the fun from 9 a.m. to 10 a.m.
It has been 2 years of party after party. And on the 17th of July,
Bomba la Sanaa wana celebrate 2-year anniversary. Thank you so much for supporting Kenyan music.
Yes, we are celebrating 2nd anniversary of your hottest weekend entertainment show.
I just wanted to wish Bomba la Sanaa happy birthday. Happy 2nd anniversary. Continue being awesome. Cheers.
Bomba la Sanaa. You know what? It's amazing. It's hot. Thank you for supporting Kenyan music.
What's up, guys? It's your favorite girl band, the Bambeka, and we want to wish a 2nd anniversary to Bomba la Sanaa.
Bomba la Sanaa.
Bomba la Sanaa.
Bomba la Sanaa. 2 years of Bomba la Sanaa.
we are the party.
Of course, we are the party, and thank you so much kwa support yenu miaka miwili kwenye burudani. Mama!
Zazi, muchas gracias. That means thank you so much in Spanish.
So, did you hear about the farmer who was trying the mushroom? Well, watch hizo. I know I'm utterly hilarious from my head tomatoes. Nitaacha na kudragon na hizi farming jokes basi. I was only trying kukuchekesha. Okay, I'll stop. I know my jokes are not very funny. But I know you'll want to know the different kinds of farming we have here on Kilimo Diaries. Join me, Sandra Wahito, every Sunday at 7:30 p.m. only on TV47.
Why crocodile inaweza tokea juu. Hiyo sijakula hata unataka nikufe kabla ni. I don't like it. I don't. Miss Kai na hipo ikitokelezea ivuruche simu yangu. No, ni sawa. Those who know me will tell you I'm not a lover of large volumes of water. But for you, we rove the different parts of the country and beyond just to make sure that we bring you the experience. We educate you, we entertain you, and we inform you.
That it's not political and it can do something.
As we sail the boat of Morning Cafe to enlighten you, entertain you, and inform you every Monday to Friday, only on TV47.
Excuse me, you dropped a coin.
Just 5 shillings.
5 shillings? Just 5 shillings? It all begins with just 5 shillings. Whether it's the Juakali industry.
Every challenge is an opportunity to really rise above the challenge.
Yeah. Biking industry.
Any kind of business, just start.
Or the art industry. We here at The Grind know it's not entirely about the 5 shillings. It's not about the money that matters. It's what you do with the money that counts. This and much more on The Grind to have a profitable day. With me, Violet Njoki, every Monday at 7:30 p.m.
Woo. Construction can be quite a task, but how do you move from finding your piece of land, sourcing the right materials, getting the right labor force to put up your building? Or better yet, how do you source for a building that's already built?
Just a small size of land can suit just a big maisonette because you are going high.
How do you ensure you get the right finishes to bring out the aesthetic value of your property and make it not only look good, but also feel good?
The buyers in this area
other buyers who are able to pay cash?
Well, we have it right here on The Realtor on TV47, where we demystify building right here in Kenya and analyze the property industry for you to take advantage when acquiring your next piece of property.
Save a Life ni shirika la kijamii ambalo linakuletea hadithi za kuhamasisha ili kubadilisha na kuokoa maisha. Tunawapa msaada wa matibabu wale ambao hawajiwezi. Vilevile tunaboresha maisha ya familia na pia kuwapa vijana mafunzo ya vyombo vya habari. Jumuika nasi hapa kila wiki tukikuletea hadithi hizi za kuhamasisha.
Service to humanity is service to God. Save a life. Transform a life.
A vigorous soap opera about two lovers fighting against their relentless fate, which opposes them in the heist of murder, lies, betrayal, and secrets of those who claim to love them. Sylvia and Bruno Alvarado will do whatever it takes to get rid of anyone who interferes with their plans. The paths of Maya and Alberto cross under a devastating storm. Right there between the tempest, a love that will provide a strong reason to go on will arise.
Me llamo Mía. Le voy a dar algo. Para que lo cuide. De veras que le hace falta. Nos volveremos a encontrar.
Me llamo Alberto.
Oriana Roldan is between Maya and Alberto, a renowned bullfighter with a psychotic personality, willing to do anything to regain Alberto's love.
¡Te estoy hablando! Mía, niña, suéltame, hermano, no, Mía, te estoy hablando.
So Much Love, Monday to Friday at 8 p.m. only on TV47.
Every February, we hear men joking about going to a men's conference on Valentine's Day. We laugh about it, the lucky ones end up having a decent Valentine's Day, and we move on. But what we do not know is that men actually do meet up. Men do sit down and have conversations about things that affect their day-to-day life.
Let me ask, does money make the man?
Give them the gifts, shower them with everything you want to shower them with, but keep your money to yourself.
I, for one, have always been curious as to what goes on in a man's mind.
To consult the Public Service Commission before he appointed, or before he published the Gazette notices that appointed the task force and the steering committee. Our reply to that, my lords, is that that provision is to be found in Article 132, Sub-Article 4A of the Constitution. And for that article to be operative, my lords, the office concerned, or the office to which an appointment is being made, needs to be an office within the public service. It is our submission that those offices were not offices within the public service. The relevant statutory authority for the appointment of the steering committee and the task force is the Commission of Inquiries Act. And that legislation enables His Excellency the President to make the appointments like he did on his own, as and when he deems necessary, without having to consult the Public Service Commission. The second issue which I wish to respond to, my lords, is the issue where we started and the issue where many of the substantive respondents in this matter have started, and it is the issue of basic structure. And I wish to commence my response, my lords, by stating that the term basic structure and the term basic structure doctrine have been used interchangeably as if they mean the same thing. It is our submission that they do not. The basic structure doctrine is a doctrine that, where applicable, restricts the manner in which a constitution may be amended. And the basic structure of a constitution is just what the term suggests, a fundamental structure of a constitution, and that basic or fundamental structure may even contain certain entrenched provisions. These are our submissions, my lords and my ladies, that our constitution does not, or the basic structure doctrine is not applicable to the Constitution of Kenya. And whereas the Constitution may have certain entrenched provisions, they are entrenched, my lords, only to the extent as provided in Article 255 of the Constitution. They are entrenched, my lord, not that they are not amendable, but they are amendable by a different procedure. From the other articles in the Constitution. And for the record, we want to state emphatically that there is no provision in the Constitution of the Republic of Kenya that is unamendable. My lords, my ladies, there was a submission by our learned colleague, Mr. Elisha Ongoya, that seemed to suggest or seemed to accuse my learned senior, Mr. George Oraro, senior counsel, and myself for being one of the advocates that my learned senior colleague, Dr. John Kamino, had submitted about earlier this morning, who are making submissions or who are urging positions that they did not really believe in. And he seemed to make that submission by reference to the CIC decision, Justice Lenaola's decision in the CIC matter. This decision is to be found on pages 4,112 to 4,212 to 4,240 of the main bundle of the Attorney General's bundle of authorities. And the reason perhaps my good and learned friend Mr. Ongoya made that submission is that myself and my learned senior colleague Mr. Oraro are here urging what perhaps may seem to the unkeen observer a different position from what we urged in the CIC matter. And I wish to respond in two ways. First, as advocates, we retain no agency in the matters that we urge before courts. We owe fidelity to the law and to the Constitution, and we have a duty to the courts before whom we appear. The exposition of the law in respect of basic structure contained in the CIC decision is correct. The CIC decision was in respect of an attempt by Parliament to amend the Constitution by way of Article 256 and not 257, as is the case in the matter before this court. So, my lords, CIC is and was correctly decided. There is no need for counsel appearing before the court to argue matters consistently, but even in that respect, we have argued, we have retained the same position. And yes, we do believe in the submissions that we have made before this court during the duration of this appeal. We wish to state in reply that this court's decision in the matter of the Senate and 48 others versus the Council of Governors, which has been referred to severally, contains a correct exposition of the law in respect to the restrictability of the amendment provisions that are to be found in Chapter 16 of the Constitution of this Republic. I wish to move on to the next issue in our reply. And during the course of the hearing of these appeals, it has been roundly accepted, and it is common ground between the appellants, the respondents who support the appellant's position, the respondents, and the respondents who oppose the appeal, that one Professor Yaniv Roznai is an authority in respect of the matters or in respect of the issue of basic structure, which is an important issue in the appeals that are before the court. My lords, my ladies, other than being an acknowledged expert in the matter, I wish to submit in response that these proceedings have been of particular interest to Professor Yaniv Roznai. And on the first day of the hearing of this appeal, Professor Roznai seemed to be following these proceedings, which are now online, and the world is indeed a small place. And on the evening of the 29th of June this year, Professor Roznai...
Is what you're saying, is it on record?
No, it is not on record, but it is important.
And do the others have what he wrote?
It is available. I have just come across it, but I think it is important and it doesn't prejudice anybody if a current thinking...
It may be, but I'm afraid that we will now be opening a new ground and we will not be giving them an opportunity to respond.
Okay. I will then refer to Professor Roznai's book that is on record. My Lord, the book is entitled Unconstitutional Constitutional Amendments.
Yes.
And my Lord, I wish to refer to the book and not the thesis. The book is to be found at page 374. Of the Attorney General's first volume, volume 1, in his main, in the Attorney General's main bundle of authorities. My Lord, I wish to refer you to a passage that appears in page 622. My Lord, it appears in a chapter or part 3 of the book entitled Enforcing Constitutional Amendability. It is to be found under the chapter...
Mr. Nyamodi, are you sharing the time with your colleague? I see you have only 4.5 minutes.
I will take just one more minute. It won't take a long time.
As long as you know it will not exceed 15 minutes.
Most obliged, my Lord. So now, the chapter is entitled Exercising Judicial Review of Constitutional Amendments. The sub-chapter is called Standard of Review. I wish to refer your lordships to line 3 on page 622, where the professor says the intensity of judicial scrutiny of constitutional amendments should be connected to the amendment process. Later on the same page, at line 27, he goes on to state that, therefore, the intensity of the judicial review of amendment depends, at least in part, on the amendment process. The more the amendment is the product of multi-procedural, inclusive, sorry, let me read that again. Inclusive and popular amendment powers, which enjoy a very high degree of democratic legitimacy and minimize risk of misuse, the less intense the judicial review of amendment should be, and vice versa. He then states later on at line 13 on page 623 what should happen when the converse is true. I urge your lordships to be guided by that and to note that the amendment provisions in the Constitution of Kenya are strong. In 10 years there have been several attempts and there have been no amendments over the 10 years. My lords, I am most obliged for the opportunity to reply, and I cede the rest of my time to my learned colleague, Mr. Donald Kipkorir.
Counsel, you have 2 minutes and 54 seconds.
I'll not be able to develop my arguments, but I'll just give you the highlights of my arguments. As Mr. Nyamodi has elaborated, the basic structure doctrine is not applicable in our constitution, but having imported it into our constitution, the judges, again, of the Superior Court, when they had to give strictures onto how to apply the basic structure doctrine by giving us 4 steps in the first declaratory order, 1C. When my friend and President Nelson Havi began his submissions, he took us to Greece, and I want to begin in Greece. In ancient Greece, the classical period, between 508 and 148, the Greek cities had direct democracy, and that was constituent power. They were exercising constituent power directly, because there's been conflation of constituent power and constituent assembly. And then we go to 1789 French Revolution. That's when the constituent assembly was properly established in the way we understand in the modern times. And it was through the pamphlet of Abbe Emmanuel Joseph Sayers. What is the third estate is in our authorities. And the judgment of the High Court was basically verbatim reproduction of the thoughts of Professor Joel Colon Rios, that amendment of the Constitution must be in a constituent assembly. And you need to understand why Rios' thoughts were influenced. He's a South American, and he wrote his books, and his thoughts were formulated during 1970s and 80s when Latin America was under military dictatorships. So Rios wanted power to be taken back to the people. And I'm going forward, at least I appreciate Ochel Dudley has given me the book by Carl Smith, the German professor, or his magnum opus, Constitutional Theory. When you read that book, it gives again that constituent power can be exercised by the monarchy or the king and the populace, the Maesta Populi. And finally, the book, all of us have referred to Professor Yannick Rosnay. In all is actually the leading authority or theorist on constituent power. But he demands in his own articles again, he says, just last minute, he says in his book that since the primary constituent power has extrajuridical dimensions, it cannot be fully regulated legally. A true constituent authority must act without the comfort of legal authority. Primary constituent power does not have to abide by it. And I endorse those sentiments by Professor Rosnay.
Thank you, Council. Thank you, Council.
Just half a minute.
Thank you.
So, it's fine.
May it please you, my lords, Gedu Muigai, for IEBC, I appear with my learned friend, Mr. Justus Munyidia. I will deal with a few points, and my learned friend will conclude. At a very personal level, let me say this, my lords. I have been in these corridors for over 3 decades. I have never seen a case like this. We don't seem to agree on anything. Not what the facts were, not what the law is, not what the concepts are, not what the words mean. We can't agree on who the people are. We can't agree on basic structure. We can't agree on public participation. And I have never been in a case where so many professors have been cited. That makes the point we started with 2 days ago. This is a case about theory. This is a case about theory. If this was a case about live disputes between live people with live grievances, we would have had very different presentations. Let me ask a couple of questions and then sit down. Is there a constitution outside the constitution itself? I understand this judgment to be saying so, that there is another constitution outside the constitution. So that if you want to know how to amend the Constitution of Kenya, you should look at the Constitution itself, then go and look somewhere else. We don't seem to be clear where that somewhere else is. I submit that there is no constitution outside the Constitution, and there is no constitutional legitimacy outside the Constitution. Legitimacy is not in politics, it's not in society, it is not in economy, it is juridical. 2, is the spirit of the Constitution superior to the Constitution itself? In my very humble view, my lord, if you ever want to know a weak lawyer, is a lawyer who begins by saying, the spirit of the Constitution requires. Why would we go to look at the spirit when the Constitution is speaking for itself?
Professor,
yes, sir.
The spirit of the Constitution is one thing that people haven't talked about during these proceedings.
Well, but this so-called doctrinal, basic doctrine, it is another word, my lord, for spirit of the Constitution. It has come in new disguise. In the old days, it used to be called spirit by poor lawyers. A good lawyer always looks at the black letter law. What did Parliament say? What did Parliament say? A good lawyer cannot start by saying, let us look at the spirit of the law. The law has no spirit unless it has been read. This Constitution has told us how to amend it. Very clear, precise terms. Question number 3. Is the amending power provided in the Constitution to be supplemented by reference to theory? It is our submission, no. The Constitution speaks on its face. 4. Is the sovereign power of the people to ratify radical changes, which is secured by the referendum here, is it less valuable than the so-called power to call a constitutional convention? Tell me this, ladies, my lords, tell me this. I was in Bomas, I was a delegate, I was not elected by anybody, I was picked by Parliament. I went, we drafted the Constitution, we voted on it. How is that better than me going to where I vote? In my village of Dumberry, I go there, I stand in the queue, I vote in a referendum. Which one is better? The Constitution of Kenya has said every Kenyan who wants to will vote in the referendum. My learned friends are saying that is not good. If you are to change radically, elect a convention. I find that argument very, very surprising. My lords, we are told that you cannot reenact the Constitution. I agree. Is this Constitution being reenacted? No. The Njoya case said, Ringera J and his colleagues said, the way we were proceeding with the amendment of the first Constitution was wrong, because we were going to overhaul it without involving the public. So Ringera was saying, you are reenacting a new one. You are not amending. If you reenact, you need a referendum and you need a constitutional assembly. And that's what we did. That is not what we are doing now. The Constitution, 90% of this Constitution is remaining intact, even under. So it is an amendment, not a reenactment, and there is absolutely no good reason for a constituent assembly. And the problem here, my lords, arises out of this problem, which has not been well understood. And I take responsibility with my colleagues. We have not made the case very well. India is a constitution where Parliament with a simple majority can make constitutional changes. That is why the court is scared that a simple majority in Parliament can take India from being a republic to being a theocracy. That in Kenya cannot happen, because in Kenya we have entrenched what my colleagues are calling the basic structure. The basic structure is protected, super protected. That's why you can't change the boundaries of Kenya, you can't change the name of Kenya, you can't change the national anthem, you can't change the independence of the judiciary. Those are super protected. Kenya and India are like day and night. So this case that has been cited is an irrelevancy. When they say eternity clauses, a clause is a written provision. It is not being read from the air. It's not a straw that is being plucked from the air. An eternity clause is written in the Constitution. If Kenyans wanted eternity clauses, they would have written them. We didn't, and they don't exist. Now, let me say two things, so I allow Mr. Munyidhi his 5 minutes. Our submission about IEBC quorum has probably not been understood by our adversary. The court declared the provisions on quorum unconstitutional. And what we are saying is 0 minus 0 is 0. Once the provisions on quorum were removed, there was nothing to go back to, because the legislative process is first of all, you delete. When you delete, you then add the provision you want. The one you have deleted is no longer available for application if the one you have added is found to be unconstitutional. It's a simple argument, but we had not made it well. There is an argument made by Dr. Kaminwa, my two distinguished colleagues, Elisha Ngoya and Mudomi Thionkolu, which is mind-boggling in my very humble view. They say, if there are no regulations, Article 257 is dead, and we therefore cannot say we have a framework. Now, this is exactly where Dugdale J. took us in 1986. He had said you could not enforce human rights in Kenya because the rules for the enforcement of human rights had never been promulgated by the Chief Justice. I thought my colleagues were the progressive side of this divide here, but this is a very backward view of the Constitution. Titus Alila versus the AG in Kisumu put it very, very well. It is not the function of the judiciary to determine in general terms whether or not the said statutes were inadequate or inelegant. That was Ochieng J, and we urge my lords to adapt that reasoning, because in our very humble view, it is the correct reasoning. Thank you very much.
May it please my lords, for record, my name is Justus Munyidhi. I will address a question that was raised and which Muhuri raised, that there is no adequate legal framework to conduct the verification of signatures. My lord, looking at Article 88 of the Constitution, Article 88, 4 and 5, the IBC is supposed to follow the Constitution and the national law. And the provision that it's supposed to follow for purposes of verification is Article 2574. That is, upon the receipt of the list, they are supposed to verify whether these are registered voters. The national law applicable is the Elections Act, and it is captured in the preamble to the Elections Act, and in particular, if you go to Section 4A of the Elections Act, you will find that there is a requirement to come up with a voter register. And pursuant to us, the IBC developed Regulation 8 that requires biometric register to capture, to have a data captured. Now, the definition is in section 2 of what biometric features are. And among them are signatures, a thumbprint of a voter, the constituency, the ward, the surname, the identity card, the passport, date of birth, residential address, contact, postal address, email, and any disability if a voter has one. My Lord, when you want to identify a voter, you get there to know whether these are registered voters or not. And the second thing, after identification that these are registered voters, you again submit the list back to the promoters and also publish it so that those who might be complaining that their names could have found themselves in that list could be struck out. And that is exactly what IBC does. My Lord, the administrative procedures again are developed pursuant to the provision of section 55 and 53. Nothing limits the power of the Commission from developing an administrative mechanism to deliver to the right order what they have asked for. For Muhuri to say there is no adequate law, or for the respondent to say that there is no law to deliver to them as a referendum, it's wrong. My Lord, I'll also refer you to Legislation 11 regarding continuous registration of voters. There is a requirement, yes, and that was demonstrated by the Gazette notice that was exhibited here, that there is continuous registration of voters. But this should not be mistaken with the periodical registration of voters, especially towards an election when you have the campaign drive to register voters. That is a mistake that was happening. This question was answered, but they started saying the numbers are not enough. My Lord, Kenyans are free to register to be voters. You can't force them to do so. If a drive is initiated, yes, they can be able to do that. Again, voter education, the word civic education was introduced. When you look at the wording of Article 884, they say the mandate of the Commission is to develop voter education. And you go to the statute, you find that IBC will develop a curriculum for voter education, which would be done in consultation with others. In our submission, the law is sufficient. Let us not dwell into the realm of the Law Reform Commission. Let us not dwell into the realm of revision of the laws. If the law is found to be inadequate at the opportune time, that will be done. And my Lord, my learned friend has pointed out that Judge Ocheng pointed this when the first initiative of Okwa came. The Third Way Alliance, who are here as respondents, also had Punguza Muzigo. Again, in the history of this country, let us not just look at before 2010. Let us look at the history after 2010, where the referendum or a popular initiative has been attempted. It's only Wasinisu County which was able to attest or pass the bill for Punguza Muzigo. Maybe if other counties passed it, we'll be talking about a different history.
Thank you, Mr. Munyidia. Thank you, thank you, thank you.
Please, the court, very quickly, the submissions by the respondents are an invitation to this court to violate the Constitution, and I'll try and illustrate that in my responses. Let me start with my learned friend Nelson Harvey. He says the president is not a person for purposes of the Constitution, and he is supported in this by Isaac Aluchier. This violates two provisions of the Constitution. First, Article 152, Subarticle 2A, which says the Constitution is for all. Justice is to be done to all irrespective of status. It also violates Article 19, Subarticle 3A, which says the Bill of Rights, the rights and the freedoms in the Bill of Rights belong to each individual. The president is an individual. The president is a citizen. He's entitled to the same protection as my learned friends and I are. The rights set out in the Bill of Rights and in the Constitution in general are very categorical. In some places they refer to citizen, in some places they refer to person. And I'd invite you to look at Articles 26 through to 43 to see this. When my learned friend suggests that once a person is elected president, he gives up his rights, this is a violation of Article 24 as well. Chapter 6 does not take away any of the president's rights. So that when my learned friend Mr. Ian Madenge says that he has looked at Articles 131 to 133, where the functions of the president are listed and he does not find initiating constitutional amendments, with respect, this is the clearest example of a failure to interpret the Constitution holistically. He deliberately disregards Article 119 and Article 38. Let me quickly look at the cross appeal by the 76th respondent. Once no party has challenged the finding of the High Court in paragraph 494, which was to the effect that the president was discharging his official functions, the cross appeal is dead in the water. There is a decision that he was discharging his functions. Then we go to ex parte Pinochet, and I'll not refer you to the paragraphs, you'll find it, I think 38 and 39, where they said so long as you are acting within your powers, then the immunity is absolute. That's precisely the objective of Article 143 sub Article 2. What the respondents are asking you to do is to tear up this provision. My own friend Mr. Gatonya will deal with the question of service, but let's look at the cross appeal by the 76th respondent. Nobody has even suggested that this petition was served on the president. All you're being told to do is to say, because we placed it before the court, we must ask you to make orders against the president. What happened to his right to a fair trial? He lost this when he was elected? What are the rights? Mr. Harvey says he left these rights at the doorstep. Which are the rights did he leave at the doorstep? He doesn't tell us. Did he lose his right to life? This argument, taken to its logical conclusion, is dangerous. My other friend, Mr. Murara, I believe it was, says that Mr. Andole, I beg your pardon, says that they don't need to provide any evidence before an order for a refund can be made. This is tragic. This is the first time I'm hearing that a court can order money to be paid without evidence. They're saying it's strict. Tell Mr. Uhuru Kenyatta to give us back our money. How much? Why? This is why I suggest, or I submit, that they are asking you to disregard the Constitution. My learned friend Mr. Mutuba says that Mr. Justice Mativo's decision is not binding on you. Agreed. He also says that the parties were different. Now, the whole concept of res judicata encompasses situations where a party is required to state their whole case. They have admitted they placed the task force report before Mr. Justice Mativo. But this is where the trouble lies. They say, we gave it to you, Judge, for purposes of finding in our favor the task force is unconstitutional. We, however, reserved our right to come back to court and say anything emanating from that task force report is unconstitutional. We want to have another bite. Again, this is the clearest example of abuse of the court process. State your entire case and allow your opponent to respond to it. My learned friend, Mr. Ogada, says that the judges have been vilified. With respect, our law, our constitution recognizes a hierarchy of the courts, so that if we come before you and say, we think the judges below erred. And just to use one example to illustrate this, on the one hand, in paragraph 494 of their judgment, they say, Mr. Kenyatta was acting in his official capacity. They then do an absolute somersault and say, he violated the Constitution in setting up the BBI steering committee. It can't be both ways. It is your job, in my humble submission, to rectify that. My learned friend Mr. Dudley Ochiel referred you to two decisions. Look at the Katiba Institute case, and we can't go into this into any great length because this matter is before this court. But indeed, the High Court did come to the conclusion that Mr. Kenyatta, as a president, should not be a party. With regard to the Nixon case, again, I ask you to look at it. The circumstances are different. Let me now hand over to Mr. Gatonye, but before doing that, I was a little surprised when I heard Mr. Aluchier referring to a supplementary record of appeal, because I looked at the one that you have and looked at the one that was sent to Mr. Gatonye, who's on record, and for some reason they're different. The one that I have does not have the affidavit of service, but Mr. Gatonye will address you on the affidavit of service. I had a quick look at your supplementary record of appeal, and the one thing I noted is that although there is an affidavit of service, I did not see the court receipt. So we thank God for technology. Mr. Paul Wanga, who is Mr. Waweru Gatonye's partner, and you can go on the portal and check, has checked. There is a receipt issued on the 26th of May, 2021 for an affidavit of service. Whether it's the same affidavit of service, I do not know. But the point I am making is that if you look at the submissions, if you look at the response by Mr. Aluchier to the application under Rule 52B, which is in our supplementary record of appeal, he admits not serving Mr. Uhuru Kenyatta. Personally, he says. He then produces an affidavit of service, which, look at the email. Whose address is this? It says it came from the court. I will leave Mr. Waweru Gatonye to address you on the question of service. The issue that I must ask you as you retire to ponder over is, at what point in time should the High Court have determined whether or not the President was acting within or outside the Constitution? In my humble submission, this should have been done at the outset and not in the final judgment.
Mr. Gatonye.
My Lord, can you allow me to address
you can sit. You can sit.
Thank you so much. My Lord, we have just witnessed.
Just put on the microphone, please, or you bring it nearer.
Yeah. All right. Yeah, my lords, we have just seen or witnessed a very unusual scene of a litigant who became very emotional for the reason that he was told he had not served His Excellency the President with his petition. My lords, the provisions of service for a petition under the Mutunga rules are contained in Rule 14. The rule requires service within 15 days of filing a petition. And my lord, you are required to evidence such service by an affidavit of service in a prescribed form called Form B in the Schedule 2 of the rules. Mr. Oluocha has come to court and has said that our client is only trying to play with the technical rules. It is our humble submission, my lord, that our client has never been served. My lords, after the judgment was entered in this matter in May, we filed an application under 52B and served it upon Mr. Aluocha. And in answer to that application, he filed an affidavit sworn. My lords, it is sworn or dated 31st May 2021, which we have included in our supplementary record of appeal. dated 7th day of June 2021. My lords, allow me to read the words of the respondent set out in paragraph 10. And my lords, we should not lose sight of the fact that he is making this averment in May 2021. And he says, notwithstanding that he was not personally served, the applicant elected to enter appearance in consolidated petitions number E282 of 2020 after the judgment delivered on 13th May 2021, and is now participating in consequential proceedings, including the instant application and his intended appeal, clearly implying that the applicant was indeed aware of the proceedings in consolidated petition number E282 of 2020 and the fact that he was the respondent in petition number 426 of 2020. My Lord, he admits he did not serve the respondent directly. But it is important to note, my Lord, he did not state that he served the respondent in any other way. My lords, I need not tire you reading out the contents of paragraph 11 and paragraph 12 and 13. But my lords, in those paragraphs, and you'll have the opportunity to have a look at them, he is justifying that it should be taken that our client was served for the simple reason that he alleges he is represented in some other petition, associated petition. In other words, my Lord, that he knew that there existed some cases against him, and that to him amounts to service. And you recall, my lords, when I present the case for the appellant in the first instance, the Attorney General who represents the national government was disqualified by the court from representing or purporting to represent the president in the consolidated petitions. Yes. But you recall again, my lords, this is at the judgment stage, is when the Superior Court was writing its judgment. In our humble submission, my lord, there was need for the court to ascertain that parties had been duly served before the trial began. But the most important consideration here, my lords, is this. If Mr. Alucha had served the appellant, as he says, when the issue of service arose in May, he ought to have responded right away and provided the evidence of such service.
Thank you, Senior Counsel.
Yeah.
Mr. Katonya, thank you. Thank you.
I'm obliged, my lord.
My lords, my ladies, I'll take 15 minutes and try to use them as quickly as I can. I want to take from where my other friend Professor Githu Muigai left. And remember, he said at the beginning, it's a long time since we appeared on a matter of this nature on the same side. But I agree with him when he says we are here not to address theoretical questions. We are not here to address hypothetical questions. We are here to address very concrete questions of law. And my Lord, when I was listening throughout to those questions that I think are important for the determination of these appeals, I did not hear the same kind of oration on those specific themes to enable this court to arrive at a decision. And for me, really, there are 5 issues. The basic structure doctrine, the doctrines of interpretation in relation to the matters that are before your lordships and your ladyships, the question of popular initiative and public participation, and finally, with a subset of themes, is the issues around IABC and the question as to verification and a regulatory framework. These are the concrete questions before your lordships. And I must say that if we were clearly crystallized these questions and addressed you on these matters, probably we should not have taken as long as we did. But as a starting point, my lords, I want to persuade you that this Constitution of Kenya 2010 was trying to address a very critical question. And I want to take your lordships to the French Revolution. One of the most important documents that came out of the French Revolution was Les droits d'homme et du citoyen, the rights of man and the citizen. It is the basis upon which even United Nations instruments on human rights are based. My lords, after the French Revolution, when the 3 estates met in Versailles, the 3 estates were the clergy, the commoners, and the noblemen. Within 2 years, there was a reign of terror. There was a reign of terror by one, prosecuted by one Robespierre. And unfortunately, this Robespierre was a lawyer, was a statesman and a lawyer. And what he did, he just went to the communes in Paris and said, we the people, in the name of the revolution, we are taking over from the Estates General and establish a convention in which he came out as a dictator. Robespierre went to the guillotine, and after his death, there was another body called the Directorate. Again, that came to power in the name of the people. The revolution came to an end when Napoleon took over power in the year 1799. And thereafter, French interchanged monarchy, empires, republics, until after the Second World War, we had what is called the Fifth Republic. What this constitution is saying, that we the people, having made this constitution for ourselves, we are bound by this constitution. And if you want to change it, you have to go by this constitution. You cannot go to Kisumu and mobilize 1,000 people in a stadium and say, we the people, we are changing ourselves into a constituent assembly, and therefore we want to amend or change the constitution. So I want to disabuse this notion that there is a power outside the constitution, including the people. The people are bound by this constitution. And then if they want to go outside the constitution, they have the constitutional instruments to go outside it, but in accordance with the constitution. And my Lord, And my ladies, when it came to the question of the doctrine, the basic structure doctrine, everybody who went to Article 255, 256, 257, other than making a general statement that there is entrenched provisions which are unamendable, like my learned friend Mr. John Hamid, whom I respect, he did not go to the text at all. He just made a general statement that these provisions are not amendable. The only person that I thought approached addressing that question was the president of the Law Society, who said it was implicit, just like the system of checks and balances is implicit in the Constitution. I want to inform your lordships that, in fact, even that system of checks and balances is not just implicit. You get it from the text. Article 1, 2, and 3, that talks about the delegation of these powers to the national executive, to the legislature, and to the judiciary. And in relation to the parliament, Article 94(1, in relation to the executive, Chapter 9, Part 1 of the Constitution, and judicial authority, you would find it in Article 159. And these checks and balances is both horizontally and vertically. And that is found in Article 174, H and I. You will find that the system of checks and balances does not just apply vertically, nationally, but also to devolve government at the counties. Now, the very important question which we must address is the question of popular initiative and the question of promoters. My Lord, in our reading of the Constitution, first of all, to qualify for a popular initiative, I want to persuade your lordships that Article 257, Sub-Article 1 and 2, is about qualification and attaining the threshold. Is a trigger mechanism for a popular initiative. For example, if you want to run as president, the qualification requires that you have 2,000 signatures in at least 24 counties. Before you present your papers, you have to have 2,000 subscribers in 24 counties all over the Republic. In our submission, therefore, Article 257, 1, 2, 3 is about qualification. And the reason why it is qualification, my lordships, you'll find that from sub-article 2 up to sub-article 8, when the bill is introduced into the National Assembly and the Senate, what has been formulated is not a bill, is a draft bill. It's not a bill. For you to qualify, you have a draft bill, and you have 1 million signatures, and then you have the support of 24 counties. Once you have a majority of 24 counties, that is a constitutional step that you must attain before you can go for a referendum. And therefore, my lords and your ladyship, this question of popular initiative, I think, also can be addressed in a commonsensical way, like I've read in some judgments of Justice Kiagi. Is that president without political rights? Can he go into a booth and vote? Can he become a member of a political party? Can he be a member of the village, circle? If the president can be these ordinary things, including being a voter, I do not see why he cannot be a promoter. But we're not saying that in this instance he was a promoter. The documentation is clear from the record and the bundles and the records of the IEBC The promoters were Junet, Mohammed, and Waweru, and IEBC confirms in their communications between the promoters and themselves and with the counties. My Lord, I would want to plead with you. In the real world, if we live in the real world, and I wish Martha Karua was here. We're talking about a rotten society. When I used to be with him in Parliament, somebody used to go around with a bicycle and calling us pigs in Parliament. I saw the same bicycle yesterday, passing by the office of the President, using similar terms. About 3 weeks ago, I saw him near the court here, saying that the judiciary is corrupt. There's a day he was passing next to my chambers on Standard Street and saying lawyers are corrupt, lawyers are thieves. I think when we're dealing with a problem which is a national problem, we have to design the kind of instruments we deal with instead of calling each other people names. When Mandela shook hands with de Klerk, there were murmurings within the movement that he had betrayed the cause. In this process, I urge you, your lordships and your ladyship, come back to what is before you, the concrete issues that are before you, and ensure that the sovereignty of the people is not compromised or curtailed by judicial intervention before the process is actually ripe for judicial intervention. In our bundles here, bundle number 18, bundle of appeal, you'll find that there are records of public participation or indications of public participation in nearly all the county assemblies and parliament. And from the J-Light report, you'll find that even the Law Society took part in that process. The judiciary took part in that process. The only problem was that this matter went to court before these matters were fully ventilated in the county assemblies, in parliament, and at the time when it was said that the signatures had been collected. I think that should not have happened. And the court, you find, did not pronounce themselves on the question as to whether there was public participation in the county assemblies or in the National Assembly. So they stuck the question that there was no public participation during the collection of the signatures and before the handing over of the signatures to the IEBC. Finally, I want to share you just a matter of grammar in Article 154 or 257, sub-Article 4. I've not done Luo grammar or grammar in the Luo language or in French, a little bit in French, but in English, if you use a pronoun or a noun before a verb and is followed by a noun, that verb is a function of the pronoun or the noun before the verb and the noun following the verb. But if you have a sentence that is broken and thereafter you find a noun and another verb, it cannot relate to the noun and the pronoun that preceded the second verb. So if you look at,
can you simplify that?
If you look at Article 257, it's broken in two parts. The operative verb, the first one is deliver, and what do you deliver? Signatures. The second verb, which is a function of IEBC and registered voters, is to verify. So there's a distinction before delivery.
All right.
And
thank you, Senior Counsel. Your time is up.
I'm much obliged.
Thank you. But that was a good English lesson.
My Lord, my name is Topua Lesinko. I appear for the 76th respondent in relation to the cross appeal that was filed. My Lord,
Sorry, you are who?
Topua Lesinko for the 76th respondent. Mr. Morara Omoke.
You are not one of the appellants, are you?
No, my Lord, but we had filed a cross appeal, and I just seek your indulgence under Rule 27 and Rule 2 of this court that we may be entitled to a reply as well.
Can we finish with? Are we finished with the appellants? Just a minute before we come to you. Okay. Now. Mr. Kwale, we will give you 5 minutes. We still have one appeal to do, Mr. Kanjama's appeal. Proceed.
Okay.
No, proceed. I say proceed.
Thank you.
5 minutes.
Yes, my Lord, that will do. My Lord, the 76th respondent had filed before this court a cross appeal containing 7 grounds.
Just go straight to the same, yes.
And my Lord, we note that not a single ground has been controverted by the appellant. It's the 76th respondent submission that based on the finding of the Superior Court and indeed on our submissions, and I'll direct you, my Lords, to paragraph 144 of our submissions, that the prioritization of the amendment by the President in contradiction of Article 257 and commencing amendment of the Constitution in the midst of a COVID-19 pandemic is unconstitutional. The President, my Lord, has an obligation under Article 201 to ensure that there is accountability, transparency, and bring a balance between competing interests in issues of public finance. My Lord, the 76th respondent that filed a supplementary affidavit sworn on February 19, 2021 in support of petition E416-2020. And my Lord, we had adduced evidence that indeed the referendum will cost Kenya shillings 14 billion, while the signature verification will cost a total of 93 million based on the estimate by IBC, and this can be found in volume 7 of the AG Record of Appeal at pages 2875 and 2886. And my Lord, that it's even public knowledge that the BBI steering committee has been drawing, my Lord, allowances from this illegal process. This is a blanket violation, my Lord, of sustainable development principles as enshrined in Article 10 of the Constitution, and that this court, my Lord, has an obligation under Article 226, sub-Article 5, that any public officer that commission illegal use of public funds can actually, my Lord, be ordered to make a refund of such money expended in an illegal process, my Lord. My Lord, as you also retire, this court, my Lord, may need to consider, my Lord, whether indeed the Auditor General can be moved pursuant to Article 229 to audit the money expended in the illegal BBI initiative. My Lord, finally, the 76th respondent says that this being a public interest litigation, that each party bear its own cost, and my Lord, we note that all government entities, my Lord, presented before you have hired, my Lord, seasoned litigators who, my Lord, will be paid from public coffers. And my Lord, this country is actually struggling. Right to health have not been met. people have not been vaccinated, by, my Lord, in the midst of COVID-19 pandemic. It's only fair, my Lord, that this court, relying on the case of Jasmeer Singh Rai, Vastaroch and Singh Rai, and for others 2014, that each party, my Lord, should bear its own cost. Should bear its own cost, my Lord, and that no money shall be drawn from the public coffers, my Lord, for payment of these very senior lawyers before you today. My Lord, as I close my submission, indeed, Dr. Mugomi Biankolu yesterday said that the monster is tired, the monster is galloping for fresh air, it can't breathe. My Lord, the monster, the BBI, the Impugn Constitution of Kenya Amendment Bill 2020, is actually struggling for breath. It has resigned to fate. My Lord, the monster is saying, allow me to rest. My Lord, it's only fair that we should let it rest in peace for the interest of all Kenyans. I humbly submit, my lords, and I wish you a very fruitful deliberation as you come up with a final decision on this matter. And we just reiterate, my Lord, as a 26th respondent, that indeed the learned judges had responded in May 13th. I hope, my Lord, that you can only affirm that. Thank you and God bless you.
Thank you.
Nothing we've not seen. There's nothing we've not seen. Angela still has the energy. God bless you. My Lord. My Lord, I wonder if the Attorney General could thank the court on our behalf.
Sorry?
On this side. I wonder if the learned Attorney General might be pleased to thank the court on our behalf. I see Mr. Geto is present.
Is it before we hear Mr. Kanjama?
Oh, my apologies. I thought we were done.
No, well, we still have Mr. Kanjama. Thank you very much. Mr. Kanjama?
May it please the court, on behalf of the appellant in appeal number 307, I'm Charles Kanjama and I'm acting with Mr. Matthew Muoki. My Lord, we've also filed an application in appeal number E348, and we'll ask the court to consider that application and the submissions we have filed therein.
Mr. Kanjama, the application in 348, it has not even been served. I think it came in, it was filed yesterday. It is not ripe for hearing right now.
Very well.
And by the way, this one, 307, let me seek your clarification. It was not consolidated with these appeals.
Yes, my Lord, and in fact we are submitting for the 30 minutes in accordance with the directions that you had been given.
So just hold on. Mr. Kanjama, I was confirming with the bench that had your application, and indeed what I had alluded to is correct, that it was not consolidated with the ones that we've had. So let's first of all make an order on the process that we finalized, and then we come to you as even though it will still involve the other council.
Most obliged.
So take a seat. Well, parties and council, on behalf of this bench that has been hearing this matter, we thank you for your active participation, very good preparation. You can see the volumes of papers and documents that we must plow through. We will do that and we'll give our judgment on 20th August 2021 at 9 a.m. So we haven't risen. We still have another appeal 307, which we want now to go into. It will take about 30 minutes.
My Lord, in respect of the concluded consolidated appeals, I want to thank the court on behalf of all these advocates as their chief servant and as their employee number one. We are very grateful for being given the opportunity to litigate on this important issue, and we wish the court the very best as you adjourn to write this decision. I also want to thank all my colleagues, both on the part of the appellants, the respondents, and the amici for having exercised a lot of civility as we deal with this important matter. May God bless you. May God bless Kenya abundantly.
My lords, my ladies, as representative of the Honorable the Attorney General, who is the titular head of the bar, let me also take this opportunity to thank the court and really appreciate the opportunity that, my lords, my ladies, you have accorded to all the parties in this matter to ventilate their respective cases in this very, very contested matter. My lords, the differences that we have seen in this matter and in these proceedings are understandable. They reflect the interest that Kenyans have in their constitution and constitutionalism. We are confident, my lords, my ladies, that as you retire, you will consider this matter dispassionately, and that you will come up with a decision that is fair, and just, and that is in the best interests of the people of Kenya. Let me also take this opportunity to thank all my colleagues, council and parties who are not represented by council for the manner in which they have conducted themselves. Thank you very much, my lords and my ladies.
Thank you. So to avoid unnecessary commotion, even if you're not involved in this other appeal, I'll request that you just maintain that order for a short while so that we all rise together. Mr. Kanjama.
Most obliged, my lord. The appellant hearing will be dealing with 5 broad issues. The first, I'd like to say that we filed a record of appeal with a memorandum of appeal pursuant to the orders of this court on 30th of June and submissions of the same date. And the record of appeal, the memorandum of appeal raises 7 grounds of appeal which are founded on the failure of the High Court judgment to give reasons to admit the appellant in the judgment and the consequences of that failure. My lords, my ladies, I'd refer the court to page 6774 of the record of appeal. This is the typed proceedings, and they indicate...
Mr. Kanjama, maybe before you go on, can we know whether your appeal is defended? Can we get an indication from the respondents?
My lady, because it is an appeal in which we file submissions, there's been no response, but it is an appeal. I don't know whether
I'm just asking whether there's an indication from the respondents as to whether they are opposing your appeal.
Most
because
obliged.
if they are not opposing the appeal, then we don't need to take that long.
My lady, because I know some of the issues that I've raised are issues that have also been handled in the previous submissions, I do know that there will be some opposition to some of our submissions.
I think the question that has been put, my sister, is very, very good. Can you just let us get a response whether any of the other parties are opposed to it? Because to the best of our recollection, we haven't seen responses.
If it pleases the court, my name is Awele. I appear for the second and third appellants in the previous matter that has just ended. My lord will be opposing Mr. Kanjama's appeal number 307 of 2021.
And did you file anything?
My lord, we did not file anything for the reason that the same was served on us quite late in the day. We were not able to file any document in response to that appeal.
All right, okay, we have gotten your position.
But my lord, I have a corollary issue that I think needs to be determined based on the ruling that you gave on the 28th of June regarding the manner in which this appeal was to be filed. This appeal was to be restricted on grounds for failure to give reasons on his application for joinder. If you look at the memorandum of appeal that has been filed, it goes beyond the remit that you provided and actually deals with issues that have already been dealt with in the appeal that has just ended. So I think it would be important, even as we take directions, that you clarify whether Mr. Kanjama shall be submitting on issues
The court ruling was very, very clear.
That's correct.
And the limit to which the appeal will be argued were properly defined.
Yes, but the memorandum of appeal travels out of it. So for purposes of our preparation, I think it would be good that be clarified before directions, before we take to the podium.
I think the memorandum had been filed earlier, and then the ruling came. So we will clarify that. Let's first of all get to know whether the others are opposing the appeal.
May it please my lord, my name is Moses Kipkogei. On behalf of the IEPC, we shall be opposing the appeal. And more importantly, my lord, you will note that the application which was filed this yesterday, my lord, seeks leave of the court to permit a notice of appeal, extension of time for the notice of appeal pursuant to which the appeal is founded upon to be admitted out of time. So that, my lord, it would be remiss, it would not be in order for this appeal to be heard before the application for leave to admit the notice of appeal or to accept the notice of appeal to be lodged out of time, because the appeal as it stands is incompetent. And that is what my learned friend is seeking to rectify through the motion.
Any other indication?
My lord, with your kind permission, I've just conferred with my team. This is Awele for the second and third appellants. My lord, subject to your directions on the scope of this memorandum of appeal, if Mr. Kanjama's appeal will be limited to just the failure of the High Court to give reasons for failing to join him in the proceedings of the High Court, we shall not be opposing his appeal. We can go back to the High Court and the High Court can give him the reasons for failure to join him. But if it shall be extended beyond that, then certainly we shall be opposing or rather responding to his appeal. Most obliged.
Mr. Kanjama, you could help us all. Do you have the order or the ruling of the court which indicated the parameters of your appeal?
My lord, yes, indeed, I do. And I did, after a lot of reflection and pondering and examination of the order, file a revised memorandum of appeal within time and fresh submissions within time in accordance with that order. And in my 30 minutes, I was going to persuade the court that the entire memorandum of appeal and the submissions are within the four corners of the order. But that is something that I would need the 30 minutes to do. And my request to the court is that if I'm given the 30 minutes, which had been indicated, if the court is convinced after listening to my arguments that I have gone beyond the scope of the order, then the court would be entitled to disregard. But I would need the 30 minutes.
Do we have a memorandum of appeal from you that is compliant with the order of the court?
I believe there is.
Please point it out.
The memorandum of appeal is in the first volume of the record of appeal.
What's the date?
That we filed on 30th of June, which was in accordance with the court directions.
The one filed on 30th of June?
Yes, my lord. And the memorandum is on page 8.
Is it page?
Yes, the actual grounds are on page 11 to 12.
Is it the one that starts with ground A to G?
Yes.
And you say that complies with the order of the court?
Yes, it does.
Is that the order of the court that said you shall be restricted to challenging the failure to give reasons?
My lord, if I may be given 3 minutes to just answer your question, which was going to be the first point I was going to make. The order of the court says, paragraph 12.3 on page 7, says we strike out the memorandum of appeal dated 8th June 2021 and grant leave to the respondent to file and serve another memorandum of appeal by 30th of June 2021, limited to the grounds relating to his notice of appeal anchored on the failure by the High Court to give reasons for declining his application for joinder. And the key word in that direction is anchored. And all the grounds that are in the memorandum of appeal, as I will demonstrate, have been deliberately worded so that they can be anchored on that failure to grant joinder.
When did you serve the parties with this memorandum of appeal?
My Lord, as indicated in paragraph 12, 3 and 4, I did prepare, file and serve on 30th of June because prayer 4 says we direct the respondent to file and serve fresh submissions, list of authorities by 30th of June. And also for the memorandum in prayer 3, it says we direct the respondent or we give leave to file and serve by 30th of June. So we complied strictly with the court directions.
Mr. Kanjama, the order that you are seeking in that memorandum of appeal, the second order, that a declaration is hereby made that the absence of a legislation or legal framework does not render an attempt to amend the Constitution of Kenya flawed. Does that comply with the order, the restriction that was restricting you only to the order of the court that was declining to admit you in the proceedings in the High Court?
My lady, that prayer does not, and in fact I removed it from the memorandum of appeal.
But it is here.
In the revised,
what you have.
Sorry?
I am reading what you have given us. It is there.
Prayer number 2.
Yes.
Prayer number 2 in the memorandum reads, the learned judges erred in interpreting and applying the Constitution of Kenya by failing to recognize the locus standi of the appellant to act in the public interest in respect to the test and standard of constitutional interpretation.
Is that in the one dated 30th of June?
Yes, my Lord, it is.
Counsel, what we have here, dated 30th of June, reads, a declaration is hereby made that the learned judges erred in failing to give reasons. The second one is that a declaration is made that in the absence of legislation or legal framework does not render attempt to amend etc. Nothing at all to do with failure to give reasons. That's what we have here, Counsel.
My Lord, that was my previous memorandum of appeal. When it was struck out, I filed a fresh one. I uploaded the copies and I gave also 8 physical copies to the court. And I have a copy here. And it is, the grounds are also listed in paragraph 11 of my submissions. In my submissions, I've listed both the previous grounds that were struck out as a background, and I've said they were struck out, and now I've listed the new grounds in paragraph 11.
My Lord, I confirm that what the court has read is the memorandum of appeal travels outside the order and canvasses issues on which we have been heard and are now pending judgment. Thank you.
Mr. Kanjama, I think I take the position that we can only hear you within the confines of the ruling that was delivered by the bench that had your application.
That's okay, my Lord.
All right. And Mr. Wele has said if it is limited to the issues, to the fact that the High Court did not admit you as a party in the proceedings that were before them, they are not opposed to your appeal. Mr. Who is it? The other parties. Are you? Can I know your position?
Mr. Kipkogi, IBC, do you still insist that you oppose the application given those directions by the court? IBC.
My Lord, if the orders sought by Mr. Kanjama to be allowed to go back to the High Court for reasons, we take the view, my Lord, that the Superior Court is functus official as we speak. The proceedings contains the reasons as to why he was not enjoined. He approached the court on the same day of trial, and the court told him that you've come too late. My Lord, we take the view that that is sufficient reason to deny an interested party from participating.
Okay. Mr. Ogeto and team, are you opposed to the application? Sorry, the appeal.
My Lord, for the Attorney General, the memo of appeal that we have been served with is the same memo of appeal that appears to be before your Lordships. So if Mr. Kanjama is proceeding on the limited leave which he indeed has from the bench, then that appeal is not opposed. But we don't seem to have the memo of appeal that Mr. Kanjama refers to.
I think the issue has been clarified by my Lord Justice Kiage, and we have given direction that we can only hear the appeal within the confines of the ruling as earlier given by the court.
Then in that case, my Lord, it is not opposed.
All right. Senior Counsel Gidu Gayan.
I want to consult my learned
Sorry. I realize you're on the same side with Mr. Kipkogi.
No, we have new thoughts, my lord.
I'm advised, my Lord, that we concede.
So, Counsel Mr. Kanjama. Mr. Kanjama, actually you are right. Mr. Kanjama, you actually are right. I have seen another record of appeal. Now I've been shown a volume 1 of record of appeal, but it's dated 1st of July. This is, it's 1st of July. The one or is the one that is late? Do you have?
My Lord, what happens is that we have two different appeals. One is E307, and then we have E3.
Oh, this is E348.
48, yes. So the one we are discussing now is E307, which we filed on 30th of June.
And let me just say this. In E348, which is not properly before us at all, because you haven't gotten leave, etc., you actually have complied with our direction, because the only thing you pray for there is that the learned judges erred in declining to admit you, and that they erred in failing to appreciate blah blah something about locus. And that's what they don't have a problem with. If that's what you are limiting yourself to in the other appeal that is properly before us.
My Lord, if I may just briefly give a clarification, and you are very right. Appeal E348 complies with the directions of the court, but is an appeal against the ruling, because the court decision indicated that the appellant had not appealed against the ruling of March. So that is an appeal against the ruling. But the directions of the court allowed us to pursue an appeal against the judgment, or anchored on the failure to give reasons. So we have two appeals, the one against the judgment, which is what my colleagues were responding to, and the one against the ruling. And the one that was listed for today, on Friday last week, was the one against the judgment.
If I may, Mr. Kanjama, you can see the conundrum in which we are all caught. the other parties seem to say that if your appeal before us complies with the order of the court limiting you to the issue of not being given reasons, they are not opposed. But if, on the other hand, you go outside of that limitation you are given, then they are opposed. And if they are opposed, the issue that arises is whether they have been given opportunity to fully respond to it, and that's another story altogether. You can see where you leave us, Mr. Kanjama.
My Lord, I do appreciate the conundrum, and in fact it is a deep conundrum, and I have reflected on it throughout the day's proceedings as I was listening. And I think what I have reflected is that this court is emerged in a very momentous task of considering whether Wanjiku or the public duly participated in constitutional amendment process. And I felt that it is only fair that the court itself do allow me in respect of Wanjiku or public interest to also participate in these proceedings. And that is why I felt if I have the 30 minutes that I had been assigned, I will probably say something that may be useful to the court. And if it is not useful, I'm sure my lords and my ladies can disregard what I do say.
Mr. Kanjama, with respect, this is an adversarial system, and if your appeal is not opposed, we will not hear it for the sake of hearing. We will go by your submissions. We shall not disregard the same. Because we have defined the limits of your address, and that is what we shall consider. And bear in mind that so far I have not heard any voice that says they are opposed to your appeal if it is restricted to what this court said. We have not traveled to the other appeal 348. That will be processed and you will be given directions maybe on Monday or so.
My Lord, let me clarify that I do not seek to go back to the High Court. I have reflected on these directions, and if my colleagues are conceding to the appeal, I would need a clarification whether that means the appeal is being allowed or the court will still consider, because I believe the court will still have to exercise its judicial mind.
The court has to consider your submissions.
Yes.
Yeah, we will look at your submissions and we will make a determination.
My Lord, then I would request for at least 5 minutes to address at least 3 small but very critical points.
All right, take your 5 minutes. It begins right now.
My Lord, I think the first thing I would like to say is that in making a determination about this issue of our appeal and also the substantive appeal against the judgment, the court should keep in mind 3 key principles that may help the court arrive at an appropriate determination. I seem to have been given...
Can you set the time properly?
My time has been shrunk substantially.
It was 5 minutes. So proceed, Mr. Kanjama.
Yes, my Lord, the first point is the point of accountability. And accountability is found as a national value in Article 10 of the Constitution. And my submission is that accountability is a value that applies to all the persons who are involved in the matters that are before the court for judgment, and also applies to the court itself. So that the same way that the court is scrutinizing to a very high standard whether agencies like the President, the BBI initiative and so on were accountable, the court should also check, is the court itself accountable? And one of the key instruments of accountability is giving reasons for a decision. And I have annexed several authorities to show that the High Court failed. It may have been inadvertent, but it was a mistake nonetheless. And the court should set for itself a high standard so that the court should be more ready to excuse litigants before it who may commit procedural errors than it does to itself. So that was the first point that I wanted to make. And I would like to say that in regard to accountability, paragraphs 21 to 38 of our written submissions deal with the question of the court giving reasons and the consequence of failure to give reason. The second point is that one of the key instruments of accountability and securing the constitutional goals is public participation, which is also a national value under Article 10 of the Constitution. Equally, my submission is that a constitutional court should adopt the widest possible latitude to public participation, even if it is a bit inconvenient, even if an application is made on the day of the hearing, so long as the person is not going to delay the hearing, as it would expect third parties involved in a popular initiative process. And my submission is that that same standard of public participation that requires heightened scrutiny should be applied by the court when it assesses all the stages of the popular amendment process that is found in Article 257. And this should enable the court to distinguish between the four entities mentioned in Article 210, state officer, state organ, public officer, and person. Sorry, my lady.
No, proceed.
Oh, sorry. I thought I was being stopped. And my submission is that there is a key distinction between Article 256 and 257. When Article 257 talks of popular initiative, which is public participation, it is contradistinguished to elite or representative democracy.
Sorry, Mr. Kanjama. Now, aren't you opening things that other council may want to respond to? I think you are going outside your mandate. And when you figured that somebody wanted to talk to you, I think you are listening to your own conscience, knowing that you are going outside your mandate.
My Lord, I know my colleagues have spent hours and days persuading the court as to their different views of the matter. I was within those 5 minutes. I hope the time can be stopped. Within those 5 minutes, I just wanted to make very brief points. Now I have 90 seconds. I do appreciate what the court has said. I think I wanted
Mr. Kanjama, with a lot of respect, if you looked behind you,
yes,
the arguments you're making are triggering people coming forward because they want to react. And you know that you're going outside the directions of the court. With a lot of respect, I think if you don't have anything more to say in respect to that one ground that you are restricted to, then I think we've given you the opportunity.
My Lord, I would even have taken an extra half hour.
Counsel.
I will limit myself to what the court has.
All right. Finish your 1 minute.
Yes.
Your 1 minute.
So my argument is that heightened scrutiny on public participation is the standard the court should adopt in regard to its own internal processes and also the popular initiative. The third point, which is the final point, is what is the approach or the test that the court should use in constitutional interpretation in dealing with this question. And I would like to inform the court that the High Court judgment in paragraph 399 sets out 4 tests for interpretation of the Constitution. And my feeling is that the court, in setting out those tests, failed to give sufficient emphasis to the fact that the foundation of constitutional interpretation is the text, because it is the text that gives rise to the context. So that even when the court failed to admit me into the matter, the court failed to focus on the fact that interpretation of the Constitution ought to start with the text. In conclusion, my Lord and my ladies, allow me to request the court to allow the appeal and find that the appellant had a right to participate in these proceedings on behalf of the public interest, and that in the event the court finds I had that right to participate in the proceedings, the court to consider the full submissions that have been done in writing, so that the appellant is not locked out from subsequent proceedings on the BBI matter. Thank you.
All right. Thank you very much, Mr. Kanjama. And thank you, Council, for your concession or the position that you took. Senior Counsel, you have something to say?
With your very, very kind permission, my Lord,
Yes,
I
yes.
just wanted to draw your attention. I know you are under extreme pressure already, but I wanted to draw your attention to the circumstances that IEBC finds itself in. As time is ticking very fast towards the August election, we would much appreciate, without putting any pressure, as early a delivery date as can be, the court can master.
I think we have already given a date, isn't it?
Indeed. If my lords were able to say by notice, so that there is flexibility, but not exceeding the date, the outer date you have given. It is a suggestion, my lord, because we are extremely anxious within the commission, because we have to make very, very important preparatory arrangements.
We didn't say anything to indicate that it shall be by notice. We actually deliberated on this date, looking at the nature of the matter, looking at the volumes before us. We certainly hear what you say, Senior Counsel. It is not out of disrespect, but we have a duty to perform. And you have all said this is kind of a historic matter. We've never sat in this kind of a dome before as a court of appeal. And so please bear with us. That is the date, 20th of August 2021. And allow me to just reiterate my appreciation to all counsel and parties regarding what I said earlier. Mr. Kanjama, we will give a date, we'll give a judgment in your matter on 20th of August, together with the other one. So, on behalf of this bench, thank you once again. It is now 6:20 or 21 or thereabout, and we shall adjourn.